for
Sunshine Ordinance Task Force for City, County, of San Francisco on October 2nd, 2019. On the call of the roll, Member Yankee.
Present.
Yankee present. Member Martin.
Present.
Martin present. Member Josh Wolf, absent. Member Tesfa, absent.
excused.
Excused. Member Kanata, absent. Member LaHood.
Present.
LaHood present. Member Kate.
Present.
Kate present. Member Hinsey. Hinsey absent.
I think
Member
we-
Highland.
Present.
Highland present. Chair Wolf.
Present. And
Wolf
hold on,
present. We
I
have a
think-
quorum.
Thank you. I think Member Hinsey had a, yeah, Member Hinsey is also excused. She sent word on September 17th.
There are no agenda changes that I know of at this time.
Thank you. Please call next item.
Item number 2 is approval of the minutes from the Sunshine Ordinance Task Force, September 4th, 2019 meeting.
Okay, is there a motion to approve the minutes?
I just had one question. Maybe we could take a quick look at the bottom of page 8, the motion there. This was the one we did for reconsideration of the prior one. It seems to be a little awkwardly worded because we re-voted, but the motion that we were re-voting, everyone voted no on. So we actually found no violation. And this motion says, found that the SOTF revote the original motion without changes of the April 3rd, 2019, and find that the Office of Labor Standard Enforcement violated, and then we all voted yes on this one. So it sounds like we're now finding a violation.
Oh,
So I don't know if we want to just leave it saying that we're just revoting the original motion without changes. And
Yes, what item number that is again, please?
let's see.
that was.
Item 10.
Item 10, 18081.
Right.
Moved by Member Kate, second by Member Josh Wolf, waive the complaint procedure rule regarding the requirement to request reconsideration within 30 days of issuance of the order and accept the request. I'm
The
not
motion
following.
at the bottom of the page.
Oh, at the
Yeah.
bottom.
Our page 9.
Page 9.
Yeah,
Okay.
the bottom of there.
Oh, I'm seeing.
Yeah.
Moved by Mayor Secretary that the yes revote the original motion without changes
Then it says and find.
and find the certificate violated by not providing requesters.
Because it's saying and find a violation, it sounds like we're now reversing what we originally voted.
What
I
was-
believe by the first motion, you're agreeing to reconsider.
Correct.
So I don't believe we need to say revote. Move that the SOTF find that the Office of Labor Standards Enforcement violated Administrative Code Section 67.24B2 by not providing the requested record, and that motion passes, which means...
No,
you
because
find a
everyone voted no on the original motion.
Sorry,
So when you go back to the April motion, it was unanimously voted no. So
Okay.
the motion was to find a violation, then everyone voted
So I
no
believe
on
the
it.
vote is incorrectly listed on the next page where it says ayes. Those should all be noes, and noes should be ayes, so it's backwards, and the motion failed.
Well, I think the motion was to uphold the original vote, is I think how we had voted.
I believe that when you do reconsideration, you're reconsidering the entire motion, and then you're just voting on it as if the previous vote has not happened.
That's correct. You
Okay.
bring it back to the point of debate in the debate period just before the vote.
Right, because I think before the vote you had mentioned if you're voting yes if you wanted to vote the original way. So if you go back to the meeting minutes on April 3rd, I'm looking at it's item number 7, file number 18081.
What was the outcome of that?
The motion, that motion had failed. A motion to find violation failed because everyone voted no on it.
Okay, so there were, in
So
other
there
words,
was
there
no
was, there
no
was
no violation found.
no violation. So then it was brought back for reconsideration.
Correct.
Okay, and then the vote after reconsideration was
To uphold that initial vote of finding no violation.
So there was no violation at the
Right.
end of that case?
Right.
Okay. So if there was no violation,
So the
well,
reconsideration.
I think what needs to happen is need to go back and listen to the audio to get because if it depends upon how the audio of what the actual motion, how it was, the motion.
Right,
was
right. That's what I'm
brought
saying. It's in conflict because if we're going to vote to uphold the initial motion, then everyone should vote.
forward. Doesn't say that.
May I ask, what was the intent of the task force at that time?
I don't recall.
And I think it was to affirm
Affirm, right?
the April
Of no violation?
no violation, the finding of no violation of April. We, thanks to me, reconsidered and talked about the issue a little bit more.
Right.
And then I believe Member Kanata and the vote was to basically say, yeah, we had a nice discussion, but we're reaffirming the April vote, which means finding no violation. I'm pretty sure that was the general
I will
sense of
confirm
what
with the
task force
audio,
was doing.
and if that is the case, I will amend the motion to write did not violate.
Right.
I think
'cause-
that would be, I'm suspecting that would be the change that you'll have to make, is that it just says that there was no violation to affirm the vote
I
or whatever
believe,
it says.
I believe it's just a not is missing. yeah.
Right. I think this gets to our agenda topic later in this meeting where it's kind of awkward the way we
Right.
find, right, being consistent. So I think this is
Yeah,
a good example of that.
And just for parliamentary procedure, when you reconsider a vote, there's no reaffirming of a previous vote. Of a previous motion.
Didn't happen.
It's always now that reconsideration, it's more or less rescinded. It's as if you didn't have a
Back-
motion on the
back to a
floor.
fresh vote.
So it'd be a fresh motion. That's generally, and that would most likely is the way it went. So that's why I am a little, I'm a little confused by the verbiage here. So I'm glad you picked that up.
Yeah,
I
yeah.
would just suggest that, listen to the audio again, make sure we get it the correct.
Yes, I will make sure that
language. Okay.
it reflects, if the audio does not agree, I will bring it back to you, but I will amend it to reflect that there was no violation.
Right, because it may have been, the vote may have been correct, it's just worded.
That's what I think it is. I
Incorrectly.
think we all voted aye, thinking we were voting yes to say yes to the original no.
Right,
Which is kind of a, yes, keep it. Yeah, exactly.
yeah,
Which is an awkward, very
it
awkward.
would be very awkward
Yes.
in my parliamentary mind for that to happen that way.
Probably
but-
just should have voted no again.
I think probably
right.
would have been better. But
Right. Okay, any other changes to the minutes?
that was all I had.
That's
So.
all I had, okay, great.
Is there a
motion?
second?
What?
A second on the motion?
I'll move to approve
You
that.
move to approve, okay.
I'll second.
Moved by Member Yankee, second by Member Highland. Is there any public comment on the minutes? Seeing no public comment, can we take this by acclamation? It is not substantive. Thank you. Motion is approved. Okay, let's call the next item.
May I ask, is Mr. Bruno in the room at this time? Would you like me to call the three items or one at a time?
Let's call them one at a time.
Item number 3 is file number 17097, complaint filed by Mark Bruno against the Planning Department, Board of Appeals, and the Department of Building Inspections for allegedly violating Administrative Code, Section 67.21, 67.25, by failing to respond to a public records request in a timely and/or complete manner. I'd just like to note that this file was divided at the committee level to divide the Building Inspection Department into file number 17114 and the Board of Appeals into 17115. So this item is only against the Planning Department.
Okay, is the planning department here? You are, okay. And have we heard from Mr. Bruno?
Just a history of the matter. We've tried to contact Mr. Bruno on it several times. There's been several continuances, and we did inform Mr. Bruno that we could not delay the hearing of this matter any longer, and we offered him several dates to attend. And at this point, we just scheduled it for hearing and to let the task force chime in on how you want to proceed with this matter.
Okay, great. So let's take this administratively at this point. How do we want to proceed?
So the
Member Martin.
complainant is not here.
Complaint's not here. He's been offered the opportunity several times to have it agendized. We've provided him with several continuances.
So he's already been provided several continuances. He knows it was on the agenda today.
Yeah, do you know how many continuances we've provided him? Do you have a recollection? This is a couple of years ago.
We've at least sent 2 notice of hearings, and we tried to schedule it prior to that.
Okay.
Without scheduling it on at least 2 other occasions.
Okay.
Does he know, was he aware of the hearings? Did he acknowledge receipt?
We have not heard from him regarding this hearing.
Have we heard from him regarding prior hearings?
In the past, he has asked for continuances. I believe he has stated that there's some issues pending at the court level, and he's waiting to be resolved. However, we really can't take that into consideration.
Right.
Is this in relation to all 3 of his
Uh,
matters?
yes, because this was originally one complaint against 3 independent respondents on the same issue that are somewhat, I think they're somewhat related. The EOTC had split them up because they found that they were independent issues for each one, and we usually don't like to do that unless it's the same respondent for the same complainant for 3 different, you don't need 3 different complaints.
Right.
You combine them then. So, yeah, so this will apply for items 3, 4, and 5.
Okay.
Okay, but we're taking them one at a time since they're not combined.
Okay, so I would propose that we dispense with them at this point. And
Okay, so if we're just dealing with item number 3 at this point,
Okay.
are you making a motion?
yeah, I'd make a motion to dispense with item number 3.
Okay, so there's a motion to close the file. Is there a second?
I'll second.
Second by Member Yankee. Is there any public comment for closing this file? Seeing no public comment, please call the roll.
Can I just ask one?
Yes, Member Cate.
Just to confirm with Victor, and it may have been Cheryl at the time before her leave, but do we know if Mr. Bruno responded to the July 17 email informing him that we were going to put this on, and have we heard from him? Maybe you've already confirmed that we have not.
I would not know myself, but if he did respond, we would have put everything into the file. We put everything into our files. We don't separate.
I would think if this was a 2019 or a late 2018 complaint, I'd give them a little more leeway, but this is going back 2 years, and we've spent, I think,
And
considerable time.
Just so you will know, we will send Mr. Bruno an email stating that we have closed it and offer him the opportunity to refile, reopen. And it might be a better idea to refile, as most of the parties involved in this case are not with the departments anymore that they started with.
Okay.
Thank you.
Any public comment on the motion? Seeing no public comment, please call the roll.
On that motion, my apologies, I forgot. Do you want me to call the mover first or last?
You call the mover and the second
Yes,
first.
thank you.
And the
It's
chair
been a while
last.
since I've done this.
And the chair last,
What
to break any ties.
Member Martin.
Aye.
Martin, aye. Member Yankee.
Aye.
Yankee, aye. Vice Chair Wolf, absent. Tesfa, absent. Kanata, absent. Member LaHood.
Aye.
LaHood, aye. Member Cate.
Aye.
Cate, aye. Hinsey, absent. Member Highland.
Aye.
Highland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
And just for the record, if those that you marked as absent.
I will mark them
Mark them
excused
excused.
appropriately.
Thank you very much. Okay, let's call the next item. Oh, thank you, Department of Planning. If you don't have any other cases before us, thank you very much.
Probably your shortest meeting ever.
Don't jinx.
No, hers. She's been here before us.
Item number 4, file number 17114, complaint filed by Mark Bruno against the Department of Building Inspection for allegedly violating Administrative Code, Section 67.21 and 6725, by failing to respond to a public works request in a timely and/or complete manner.
Okay, mover and second, same call? Yep, so moved by Member Martin.
Second.
Second by Member Kate now to close the file. Any discussion, debate? It's more or less the same as the previous. Any public comment? Seeing no public comment, please call the roll.
On the call of the roll, Member Martin.
Aye.
Martin, aye. Member Kate.
Aye.
Kate, aye. Member Yankee.
Aye.
Yankee, aye. Josh Wolf. Member Josh Wolf, absent. Member Tesfa, absent. Member Kanata, absent. Member LaHood.
Aye.
LaHood, aye. Member Hinsey, absent. Member Highland.
Aye.
Highland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
DBI, are you in the room? You are free to go if you have no other cases before us. Thank you. Please call next item.
Item number 5, file number 17115, complaint filed by Mark Bruno against the Board of Appeals for allegedly violating Administrative Code, Section 67.21 and 67.25 by failing to respond to a public works request in a timely and/or complete manner.
Same call?
I'll reiterate the motion.
Okay, moved by Member Martin.
I'll second.
Second by Member Yankee. Okay, same call, same item, same discussion? Okay, great. Any public comment? Seeing no public comment, please call the roll.
On that motion, Member Martin.
Aye.
Martin, aye. Member Yankee.
Aye.
Yankee, aye. Member Josh Wolf, absent. Member Tesfa, absent. Member Kanata, absent. Member LaHood.
Aye.
LaHood, aye. Member Kate.
Aye.
Kate, aye. Member Hinsey, absent. Member Highland.
Aye.
Highland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Board of Appeals, are you here? If you have no other cases, thank you for your service.
We should put off public comment until 5 o'clock.
Yep.
Give me a moment. I am turning on the microphone for Anonymous, who has called in.
Okay.
Anonymous, are you on the line at this time?
Yes, can you hear me clearly?
Yes, give me one moment while I call your item. Item number 7, file number 19047, complaint filed by Anonymous against Mayor London Breed, Hank Hankel, and the Office of the Mayor for allegedly violating Administrative Code, Sunshine Ordinance, Section 67.21, 67.26, and 67.27, and Government Code, Section 6253.9, 6253, and 6255 by failing to respond to a request for public records in a timely and/or complete manner.
Okay, complaint committee, is there anything to add to this?
Yeah, this one was relatively recent, within the last couple months, and I remember it being a little interesting because there was a metadata issue, I think, within this complaint, with a withholding of metadata by the city. So,
Withholding the metadata.
yeah,
Okay,
yeah.
right.
And I'm sure the complainant will correct me if I'm wrong.
okay, great. Okay, Anonymous, are you familiar with our complaint procedure?
I think so. I have 5 minutes initially and 3 minutes for rebuttal, correct?
That's correct. Okay. We're going to set a clock. I'm going to have the administrator chime in when you have 30 seconds left, and then chime in again when your time is up.
Perfect.
Okay, please set the clock. Okay.
Good
Anonymous,
evening, Chair. Yes.
go for it.
All right. Good evening, Chair and members of the task force. I am the anonymous complainant in case 19047 versus the Office of the Mayor regarding calendar records. Now, I have a presentation for you in the packet, so if you could follow along on page 348 or page 20 of the PDF for this item. There are 4 key questions for your task force today. The first is whether city agencies must disclose calendar records that are prepared, owned, used, or retained by the agency, but were not explicitly demanded to be created under Prop G or Section 67.29-5. And the answer to that is, of course, yes. That is the definition of a public record. Prop G cannot reduce what is a public record under the CPRA. In fact, the government has implicitly admitted that they must do this because months later, they did provide the so-called non-Prop G calendars. Second, we must ask whether city agencies must release calendars in the so-called ICS or iCalendar format when so requested, and the answer is yes. because 67.21L of the Administrative Code requires the government to release records in any format that is requested as long as it is, quote, easily generated. And for that same reason, number 3, they must release PDFs if they have to do so in a full text format instead of printing them out and scanning them, which ruins some of the resolution and some of the information. And finally, 4th, must they release the full data and metadata for each of the items in that calendar? And the answer, again, is yes. It is a record, and therefore, unless certain specific portions are explicitly exempt for security, privilege, privacy, etc., everything else must be disclosed. And if you could turn to the next page, please. I'm not going to go through the specific timeline and facts of the case, but I'm happy to take questions. On May 8th, I made an immediate disclosure request for 1 week of the mayor's calendar records in an electronic format that I specified, including all of the details and metadata for each item in those calendars. On May 9th, they disclosed a text PDF of one account of the mayor's called Prop G, Mayor. They refused to provide the formats I requested, and more importantly, they refused to provide and did not justify the fact that they had withheld certain non-Prop G calendars and the details for each event. Now, on September 6th, after a lot of negotiation, arguments, and petitions, they finally disclosed a second calendar record, not a Prop G calendar record, called Calendar, Mayor. And why they had withheld this earlier, I don't know. But they still are withholding the details of each item in that calendar and the native formats that I have requested. Next slide, please. We're on page 350 right now. So this is an excerpt of the supplemental disclosure of the non-Prop G calendar from September 6th. Now, I'll remind you, this case really is not about whether certain events are personal versus business. I know that you have considered that before. These are all government records as far as I can tell. So what can you see that has been withheld here? Well, they have provided the calendar in this daily summary Outlook format, which illegally withholds the location information because it's cut off the side of the page. It also withholds the recurrence information. As you may know, Outlook allows you to have meetings that repeat every few weeks or every few days. And unlike the supervisor of records or one of the DCAs in this case may argue, they do not hold the records in PDF format. And we have proof of that because the PDFs were generated, as the timestamp shows, long after I made the request. We can also see from this response that they, for some reason, hold 2 calendar accounts of the mayor in the government, called Prop G Mayor and Calendar Mayor. But there is nothing in the Sunshine Ordinance or CPRA that exempts this second account called Calendar, Mayor. What they have redacted, however, with black rectangles, I'm not asking for. Those are just cell phone numbers of the staff. That's exempt, I understand. Next slide. So now you may be very well familiar with what a particular item in a calendar looks like in Outlook. And it has a lot of details on this record, which is a public record, that you would be able to see, but that is not provided in the summary format they have given, including who made the event, who exactly they invited, the details of the subject, location, the exact beginning and end times, and how often that meeting repeats. There could also be attachments to the meeting items.
30 seconds.
If you look at the next slide, that is the ICS record that I'm actually requesting. And it is, after all, a plain text format. I can go through this in detail if you have questions, but there's nothing in this record that should be secret. And if there is, they can redact just that information. In fact, this is a calendar record provided by the city, the Department of Public Works, which obviously shows that there is nothing secret about these kinds of records. Thank you very much.
Are there any persons or witnesses provide any facts or evidence on behalf of the complainant, the petitioner? Seeing none, respondent, you have 5 minutes.
Chair, 1 second.
Yes.
Are you doing all right? Legal counsel?
Are you okay?
Are you okay? Yeah. Okay. Just want to make sure.
Sure.
I hear you. Low sugar or something.
Okay.
Yeah.
Good afternoon, members of the task force. I'm Hank Heckel, the compliance officer for the Office of the Mayor, here to respond to Anonymous's complaint file 19047. A lot of these issues have been hashed out in the complaints committee, and I won't go through the whole history of the request and the sort of back and forth, but Just generally to recap, there was an IDR that we responded to seeking the mayor's calendar. That was the original request. We responded to that. Our understanding was that the requester was seeking the mayor's calendar as in the Prop G calendar. That's what we consider to be the mayor's calendar because that's the official record that's required by law to memorialize all of the meetings that take place in the mayor, with the mayor in her office, and has requirements as to listing attendees and times and so on. And our production was fully compliant with Prop G. I don't think that's in dispute. The complainant also sought various categories of metadata and sought also in sort of the back and forth with him, we learned that he wanted all versions of the calendar, essentially. So with that understanding, as he's pointed out, we went back in September and we produced essentially a rough draft of the calendar, if you will, that shows the entries as they were compiled by staffers, which doesn't necessarily have all the Prop G information, but just sort of shows the details of the meeting that are used for internal purposes to schedule the mayor's meeting. So I don't think any of that is in dispute. The focus really here is on the metadata issues. We've said from the start that we objected to producing the full volume of metadata that requester is seeking. We cited the operative provisions in the Public Records Act that exempt such data, 6253.9F in the PRA, which allows an agency to withhold records to preserve the security and integrity of the original records and the software on which they reside. We've also cited 6254.19, which exempts from disclosure a record if its disclosure would reveal vulnerabilities to or otherwise increase the potential for an attack on an information technology system of a public agency. Neither of these provisions has been abrogated by the Sunshine Ordinance. The requester has focused a lot on 67.21L of the Sunshine Ordinance, and it's our position that it doesn't support the complainant's argument here. That does not abrogate the larger security exemptions in the PRA. It actually refers to simple saving and conversion steps. If I could point the task force to the language in 67.21L, what it says is an agency may provide information in any form requested which is available to or easily generated by the department, its officers or employees. Then it provides examples, including disk, tape, printout, or monitor, at a charge no greater than the cost of the media on which it is duplicated. These are physical representations of the data or recordings on cassettes and the like. Tapes doesn't say anything about metadata. It doesn't say about converting to other types of software systems that the requester may identify. It also, there's an important provision in the next sentence which says that inspection of information need not be allowed where the information sought is necessarily and inseparably intertwined with information not subject to disclosure. And I think this is a very important point because that supports our argument that the risks associated with producing both native formats or just providing some description of metadata could impede our ability to redact sensitive health information, privileged information, other sensitive information not subject to disclosure in the Act. It also says that nothing requires the department to program or reprogram a computer, which is essentially what the complainant is asking us to do in converting these other formats. So we maintain our position that we are not required to convert to these other formats or provide the metadata.
Thank you. Are there any persons or witnesses providing facts or evidence on behalf of the respondent? Seeing none, members?
Just rereading that section L, I don't think, this is written 20 years ago, I don't think that was meant to be an exclusive list of media available, so I don't read it the same way that Mr. Henkel does there. However, the next sentence about necessarily and inseparably intertwined is interesting. That caught my attention more, and that is persuasive.
I would just like to say when Prop G was created, it was specific for calendars, and in among other things, and the instructions that Prop G provides is for redactions, and including the metadata at the same time. This task force, many years ago, when PDFs were starting to be used for providing public documents to folks, it was found that the mere scanning of the document, providing an image of the document into the PDF, was not a copy of the original document. The copy of the original document must include all the data, including the metadata, and this task force has held that, and it has not been challenged to this day, even by a court, that for any other PDF that I'm aware of or that our legal counsel has provided that would prohibit the withholding of the metadata, except if it, under such conditions that information should be exempt. It doesn't mean that the entire document be exempt. It just means, especially when it's intertwined with other things, that's the purpose of redaction. And that's the way we've held things in that way. If there was a the part that Member Highland is talking about is very specific. It says inspection of documentary public information on a computer monitor. It doesn't say anything about the document itself. It just says on a computer monitor, okay, where there could be other information intertwined with it that you can't redact because it's on a computer monitor. So that is why that was in there. So it's not that it was 20 years old. This is like talking about the framers of the Constitution. Well, the framers of the Sunshine Ordinance, in their infinite wisdom, made it very clear that on the different medium that these documents could be seen. It is very clear, and it's not only in general for every other public official, but for the mayor. The mayor has produced, and it can be shown, their public calendar through the export or the copy of the actual file, and not in the way that's been presented here by the mayor's office. In fact, I have some concerns about the way things are here. Now, we only have a copy. We don't necessarily have we have a scanned-in copy. But when I look at the document that was created here, and if you look closely, it looks like that the document that is there is some standard template, and then items are then either pasted in there or somehow photo edited in some way, or maybe somebody typed it out on a piece of paper and taped it over or what have you. And this is not appropriate as far as the Prop G production is concerned. So I'm going to stop there. And I think there needs to be some further discussion about it.
I just want to apologize earlier on. I was referring, I think, to 19044. This is 19047. So this is mainly the calendar with metadata. The other one will be more metadata focused, I think. But I think Member Kate brought up maybe months ago the issue of, that you're mandated to keep a Prop G calendar. However, if you keep another calendar, that doesn't mean it's not a public document.
Right. They are allowed to keep two calendars. One is a public calendar. which can be redacted for personal items, and they're allowed to keep personal calendar. The personal calendar is not disclosable. And so we've always advised department heads up on through, going up the chain to elected officials to, keep two separate calendars. Don't intertwine them. And so that way a full calendar can be produced with the metadata without any fear of anything. Now, if there's some specific meetings that were redacted for security purposes, well, then the citation for those specific items for each and every one of them have to be shown, just like any document that has a redaction.
Right, but if they chose to keep 4, 5, 6 calendars, that's their decision, and if it contains public meetings in them, it's discoverable, correct?
But there's only one personal calendar. Everything else is a public calendar.
I'm not sure, and this is maybe a question for either party, but I think in this situation, there was the Prop G calendar, which is, what we, I think, see as the floor, the minimum requirement of what needs to be produced that identifies, who attends certain meetings. And
right.
But it appears, and I don't, that there have been another series of calendars produced in this complaint that were not personal calendars. These are other non-Prop G, so to speak, calendars that were produced as public records pursuant to the complainant's request.
That's correct. Sorry.
Yeah, and so in a sense, there's basically two versions, and I think we've discussed this before, that there's the Prop G version, and then there's some other calendar that's also being used by the mayor's office that's separate from the Prop G. And that's...
Okay, I'd like to ask Anonymous.
Yes.
Is that your understanding?
Yes. So there is, and you can see this because one of the calendars, the one they released first, has a username of Prop G, Mayor in the bottom left of the footer, and the second one they released on September 6th, I believe, has calendar, Mayor. So these are two business calendars kept by the mayor. And in fact, when they responded to me the second time on September 6th, it's not just that they responded to me. The supervisor of records actually responded to me as well and said that if you look at the good government guide, it in fact says if there are other business calendars, they too need to be released. Even though the good government guide is not binding, I'm saying that's even the city's interpretation. So.
Okay, so what are you seeking here then? Are these all the calendars that you were seeking?
There's three issues. One is I can never know how many calendars the mayor has. If you remember, I'm sorry, you weren't at the August 20th committee meeting. But at the August 20th committee meeting, Mr. Heckel argued that the other information I was looking for either doesn't exist or is private. That was clearly not true. There was at least a second calendar that they have now released. Could there be more? I don't know. But there's a much more important issue, which is the way they gave me this calendar. It's not just metadata. They're withholding non-metadata in things you would normally see on the face of the record from these meetings, as I indicated on page 350. There's no excuse to not even provide the face of those items, because what they said about what I requested is not true. You can read my exact request in the complaint. It's not just the mayor's calendar. I am very careful. I write out my requests in a very specific format. So I did request every item in the calendar as well. Okay. Like they can't withhold, like the stuff that you're not seeing on this page 350 excerpt is the full address information for each of those meetings. There's nothing secret about that. There's also other information like who created it, et cetera, as I've previously discussed. So we need, even if you don't agree on the metadata, we need every item in both the Prop G and the non-Prop G calendar.
And so it's that this is basically on 350, the example you've given us, that's basically like a cropped, I guess, image. Is that a cropping that you did of an image of a document that was produced to you, or is that, inside? So there's two boxes, right? There's the box showing the calendar, and that internal box showing the calendar lines. Did you crop that, or is that in the version that was produced to you as a
Sure.
document?
So the vertical cropping is me. I've only given a portion of it's all in the packet. But the vertical cropping is me. But the horizontal cropping, which leaves out the address and such, is them. They did that because they just felt like printing out from Outlook instead of giving each and every item individually.
May I respond to any of this?
I mean, I would I would want to hear like why or what the process was for transforming the Outlook calendar entry or the day, I guess,
Sure.
to what was produced.
Sure. So just to clarify, this wasn't the product of some kind of cropping or like piecing things together. This is a printout of the daily view of the entries as they exist in sort of the staffer's calendar, the sort of rough calendar, if you will, that precedes the Prop G. This is where the meetings are scheduled and recorded, and then they're essentially upgraded, if you will, to include all the Prop G information, and that is what's in the first version of the calendar that we provided. So we didn't sort of do some kind of cropping. We printed it, we converted it to a PDF, which we hold is appropriate, and the blockings are just redactions of things like personal cell numbers. There's personnel information relating to interviews, relating to hiring decisions that are not public at this point. And if I could just say, some of the information, Anonymous is requesting information that poses not just security risk to the cyber system of the city, but he's looking for things like recurrence of meetings, so future forward-looking meetings. And it's been the practice in the mayor's office, consistent with the city attorney's advice, is we don't provide future meetings of the mayor for security reasons, because that could pose physical harm to the mayor. It could pose other security risks to law enforcement and so on. So we can't just give out the recurrence and we can't just reproduce the calendar wholesale, exported into some raw native format as requester is seeking.
Why not? Why not? The other mayors have done it before.
I mean, I don't know. I don't have that in front of me. But
what citation are you bringing to us that gives you the ability to do that?
There's the security exemptions in the PRA, which we cited, which is in the record, and under 67.21L, we don't think that changes the analysis. I think just to kind of touch on what Member Highland was saying, I think it's a good point that when this was written, it was referring to conversion to other sort of more primitive media that we would characterize it at this point as time has moved on. So as technology has evolved, and there's all kinds of other formats and other kinds of metadata that are available, the burden is not on us to kind of parse out what poses a data risk and what doesn't. That would be incredibly burdensome to have to consult with an IT professional for every request to parse out which.
But how would you do it for any other if it was a 1,000-page document that you had to redact? You'd have to have a specialist do that for you too, right?
To redact out what?
To redact whatever information you think might be held confidential or sensitive.
Well, you wouldn't need someone with a master's degree or higher in computer science. I mean, you would just need someone who knows
You might need an attorney. You might need a subject matter.
This is beyond the expertise of attorneys,
so
frankly.
I want to take notice. You keep referring to 6721L with regards to being able to produce or generate in any form, and that is actually not correct. If you read verbatim here, inspection and copying of documentary public information stored in electronic form shall be made available to the person requesting the information in any form requested. And what's implied is requested by the person making the request, which is available or easily generated by the department.
These are not easily generated. That's our position.
Wait
One of the formats
exporting a Outlook calendar in ICS format is not easily generated?
It's not easily generated because it would require us to analyze all of the metadata.
You would have to prove that.
I'm sorry?
You would have to prove it, that it would be difficult to go through all the metadata, because everybody else does it. Everybody else provides it, and if they go through if it's painstaking or not, they go through the same process of redacting whatever metadata or any sensitive information they deem is necessary.
It's not even redactable, respectfully.
But
So
this
if you
is not-
provide something in an ICS format, which, I mean, I think the requester is asking for the native ICS file. So if you open that, that's essentially a live copy of the entire calendar. So things like recurrence information for future meetings would be in there, and there would be security risks, physical security risks to the mayor and law enforcement if we were to disclose, where the mayor is going to be at any given point in time.
Right, so redact it.
It can't be redacted
Yes, it
in a
can.
live format. That's what I'm saying.
I don't know what you mean by live.
That he's requested a native format.
It says inspection and copying of documentary public information. If you provide a copy of the ICS, that's not, I don't know what you
But
mean
how do
by
you,
live.
in what format, I guess? I'm not, an
In the
ICS
format-
is
in
a,
any format requested. He requested it in the ICS format. Whether that's considered native or not, I don't know.
it is native. It's
Okay.
like an MSG file. It's a live document. So the only way you could reproduce it and then make it a PDF, but he's already said that he won't accept a PDF.
Because that's
May I
not in the
respond to
format. Hold on, Anonymous. But that's
Sorry.
not in the format that he requested. He
Right, because it's
requested
not
it-
easily generated. That's our position.
Okay.
I mean, I
I don't
think
agree with that, but okay.
one of the things that, I understand the mayor's office to be saying that some aspects of the metadata, if they're released, they pose a security threat to the systems. I don't know enough about the IT aspects to know anything about that. But I understand the point of if there's a way and to get a static image, which is not necessarily the native file. The one possibility, and I'd like to hear from Anonymous about this, is that, again, there could be some version where you can kind of freeze the native file in time, and again, I'm very much out of my wheelhouse here, but where you have the metadata displayed, and then you redact whatever of the security concerns, or security metadata that may be, that's causing the concern that we're hearing. I don't know if that's possible technically, and maybe Anonymous can shed light on whether, because I know there's an issue of the text-based PDFs, and I don't know if even the text-based PDFs you can actually redact the supposedly sensitive metadata. Anonymous, can you, from your perspective, shed light on how you could get
Certainly.
a static kind of?
So I want to be very clear. I am not an IT administrator, but I am a computer scientist. So I want to actually talk about even the ICS is completely redactable. And I want to point you to page 353 and page 352 of the packet. What I have shown on the left-hand side column is an actual .ics file already released by the city. It is not, as the respondent would argue, some hard-to-parse file. It's plain text. You can read it as a human being without any computer science degree. You can see what is in there. I've even pointed it out. You can see exactly who's invited. It's textual so that an attorney could open that text file in Notepad, and they can just delete out the portions that they want to redact and then give me a list of redactions and justifications. And the second part is, I actually did think maybe they were right that some portions of the ICS could actually be security sensitive. I'm talking about, by the way, information technology security sensitive, not law enforcement security sensitive. I'll get to that second. But from an information technology security sensitive perspective, unlike, say, emails, which we'll discuss in the next case, in a calendar ICS file, I don't actually see anything, and I would hope that you can ask the respondent to look at this ICS file or to look at any other ICS file provided by the city, open it up, and tell you a citation of which portions of this file are exempt. Because I don't see any portion, and that's two slides, that's two halves of the file. I don't see any portions of this that can even be legitimately exempt under the information technology security exemption. It's just information like who is invited, the exact timestamps of when they changed it, who created the invite, and the description. There's no, as far as I can see, and I might be wrong, but they should point out, I don't see any IP addresses, firewall information, and stuff like that, which could be there in other kinds of files, but isn't, as far as I can tell, in this file. Now, I'll get to your second point, which is there another way to redact this using an image? It is possible that it would be silly, but they could do so. they could export to ICS, which is again a two-click step. It is easily generated as it is stated in the statute. And then they could open that ICS in Notepad, and then in Notepad they could print it to PDF, and that would preserve all of the information in textual form. And then they would use Adobe Acrobat, as presumably every attorney has access to, and they would use the Adobe Acrobat functionality to redact only those values that are explicitly exempt. And the law enforcement sensitive part, I guess that they're talking about, and I didn't understand this when they originally gave me a response, but I've done some more research. I guess what they're saying is that, security detail information, that kind of stuff, I don't care about that information. If they want to redact that, I agree with them. I think that is redactable information. But that's not an excuse if that one portion is redactable to withhold the other 90% of it. And the Sunshine Ordinance is very clear that you can only redact the specific minimal portions. So you could, if you find against me in the format case, but for me in the metadata portion of the case, have them create ICS files, print them to PDF, and then redact them in PDF. But I would suggest to them that it would be less work to them to export to ICS, just open it up in Notepad, scroll through there, and just delete with justification whatever portions they want to delete, just like they would do if they had it in a PDF.
Could I ask one question to Anonymous? One other option you gave them is to convert ICS to a live PDF, one that you can, search, do text search on, whatnot. Presumably, they could then also put the redactions in that, and then send you that as a live PDF, if you like. I may be calling it the wrong term, so you can kind of search and do what you need to do. Is that correct, as far as you know?
Could they do that using Adobe Acrobat? Yes. Adobe Acrobat allows you to, after redaction, preserve it in a text format. I mean, I've done redactions in my own work, and that is a functionality of Adobe.
Right. And actually, I think this body would probably rather see a document with redactions rather than them delete chunks and call that a redaction. That's probably more in line with what we're used to seeing. So either in the ICS or with Adobe Acrobat, but you've asked not to have it in straight, PDF documents. Is that correct?
Yeah, but there were two issues with their PDF productions. The second one, for some inexplicable reason, and maybe you need to speak to the respondent about that, it was in an image PDF format, which appears to be like printed out and then scanned back in. But the first time, they clearly provided a text PDF. So, I mean, I think they know how to provide text PDFs, and they fall under, quote unquote, easily generated.
Got it. Thank you.
May I respond to any of that, or?
Sure.
Thank you. First, I just want to apologize for any crosstalk with the between myself and Anonymous and the task force. So I'm not a computer scientist. I don't know if any of the members of the task force are computer scientists. Apparently, Anonymous is a computer scientist, and so what he's asking the city to do is employ IT professionals. Who will devote significant resources and time to advising on all the security risks posed by metadata requests where metadata is sought in large volumes. Just to get to the specifics of, on page 352, this ICS printout, I mean, there is a long list of rows of data. I don't know what 90% of that data means. And our position is that the risk is not on us to just sort of roll the dice and say, well, that's all just innocuous code. It just looks like gibberish to us. But we produce it, and then someone can reproduce, the recurrence of an event that shows the mayor is going to be at some place with their security detail, which Anonymous has conceded is redactable security information. And our position also is not just the security detail, but we don't give out the mayor's whereabouts, 2 weeks in advance, a month in advance. The mayor's going to be at this time or place, because we think that obviously can pose a risk of harm to the mayor. I mean, obviously, when things are announced publicly, they're announced, and it's all reflected in the Prop G after the fact, as required by law. There's also nothing in Prop G that requires. I forgive me if I'm wrong, but I don't see anything requiring anything about a specific format in Prop G. Yeah, 67.21. I mean, I've kind of gone through the reasons why we don't think we need to perform any programming steps. We're concerned about this inseparably intertwined exempt information issue, and again, it's referring to something that's easily generated, like a backup tape. And our position is that in the context of viewing something on a monitor, if you produce something in a native format that is the entirety of the file, that's very similar to looking at something on a monitor. So that's our position on that.
Well, I would say, Prop G was an amendment to the Sunshine Ordinance. So it's inclusive of what's required in the Sunshine Ordinance.
Of course, yeah.
So I don't think there's any dispute on that. And so I think everything that we've been talking about as far as requirements still apply. I don't see any exceptions for this particular type of document. I'm not convinced, though, of the of the fact that it can't be redacted. I mean, Prop G goes back to 1999. Okay, I mean, and the which created the Sunshine Ordinance. And as far as the calendars are concerned, there's never been any argument with regards to the ability to redact anything from it, metadata or otherwise. And on top of that, in creating any PDF, we've already adjudicated many, many times that PDFs must not be scanned in unless they are only held in, the original copy is only in hard copy, and no electronic copy cannot be found, as in the case of a pre-electronic data world, and that the metadata must be included. We've had forums here with technologists that have come in that explain how easy it is to work. And in fact, the clerk's office does that right here, even in our own agendas. They're all searchable. All the metadata is there. So I'm not compelled by that. Member Martin.
Chair Wolf, also just to clarify, I wasn't saying that the Prop G provision in the Sunshine Ordinance has any special exemptions for metadata. I was just saying it doesn't have any extra requirements beyond what you may or may not view as being required by the rest of the ordinance.
Mr. Hegel, I think when we were here in August, the complaint committee foresaw that the metadata might be a little complicated. I think we asked that the city attorney's IT professional be here. Or for the other matters, the IT professional here.
Yeah, we do have Michael Maxman is here. He's the city's chief cybersecurity officer. He can assist with any questions that the task force may have about the metadata issues on this complaint, and also the city attorney's complaint, which is next.
That's what I wanted. Okay.
Yeah.
And just to be clear, Anonymous, I think, you provide your examples on, I think, what were the pages again? 450?
352 and 53.
So 350 is kind of the big picture, what's on day-to-day, and you would also like the specifics about each event, right? Hello, Anonymous?
Hello, can you hear me? Hello?
Yeah, I can hear you.
Hello?
Yeah.
Okay, sorry. Yes, 350 cuts off even non-metadata details which you could see on 351.
Right.
And then as a separate issue, 352 and 353 show the full textual information for each of those events.
For each event during the day.
There's two issues always, yeah.
Okay. Thank you.
Can I just respond to one thing? I mean, we're happy to, in terms of page 351, which I guess is, he's saying there's different views which maybe provide different substantive non-metadata information. We're not necessarily averse to providing that on a case-by-case basis.
With my own Outlook, you see the whole day, and then you can click on each individual event, and something like 351 pops up.
Right.
And it sounds like he just got the daily when he wants the details of each event, I think.
Yeah, I mean, we can work with Anonymous on specific sort of subsets of data like that. The issue we're having is just that there's a lot of different ways. There's a lot of permutations. I mean, you could view the calendar, I don't know how many different ways. So, if there's information for an entry that isn't a security risk metadata or is not, is just some substantive information about the meeting, our position is not that we're going to withhold that.
Right. So the IT professional is here if anyone has questions for the IT. What's his
May
name?
I respond to that? Sorry.
Sure.
So actually, I would be happy. I personally would also like to know what and I assume your task force would like to know, since you have the chief of cybersecurity there, what in an ICS calendar, which is a standardized plain text format, except for attachments themselves, which are encoded in that thing, which you can see like the images on page 352. The rest of it is plain text information. So what is it that would be, and of course it's already disclosed by the city in certain cases, what is it that is information technology sensitive in these files?
I don't know. We can ask. We can ask him.
Yeah, I also want to ask Anonymous, on page 352 and 350, well, I guess starting on page 351, where did you get that document? That's
that is as it says in the source. I can't do that. So that is basically me printing out my own calendar invite that I had for setting up the SOTF task force meeting today. I obviously can't access their calendar. That's just my own calendar.
Okay, thank you.
Is this a text, or is this a text file or a PDF, or?
So
is that a question to me?
Well, I'll make it to the,
Yeah,
I guess it's sort of a rhetorical question.
So correct me if I'm wrong, Anonymous. On page 351 is a screenshot of the actual, how should I say, the user interface portion of the ICS file in Outlook, correct?
That's only half correct, and I apologize if I'm going to go into some technicality, so please stop me if that's not important to you. But in Microsoft Outlook, this isn't a view of that calendar item, but I don't believe Outlook stores them in .ics format, as far as I know. I believe it stores them in .pst format. I'm sure the IT administrator can determine that. It's from this view that you can easily create the ICS format. Does that make sense? Please ask me to clarify.
It does. And I am an IT professional. I know these
Perfect.
formats, so I understand what you're saying. You're saying that it can be saved in ICS format, and it can be saved as I think you depicted. It could be done in PDF format while retaining the metadata, correct?
No, it can't be. It can be printed directly to PDF, and I believe a text PDF, with some of the metadata, but not all of the metadata. And that is, of course, that second issue, right? There is information you'll see on page 352 and 353, which I believe is a public part of a record, but which you would not get if you printed out page 351.
Correct. Okay. Okay. What do
We
you
ask the IT person to
Sure.
approach?
Do you want to bring him forward?
Sure.
Come on up.
Good evening, Task Force. My name is Michael Maxim. I'm the City Chief Information Security Officer. Been asked by the Mayor's Office and the City Attorney to assist, and more than happy to do so today.
Great. Welcome.
Thank you.
Can you see the file that we're talking about, the pages? 352 in particular.
Don't know if I can.
Maybe we can give you a printed copy. You can take a look at it. So the type's pretty small. I had to expand it on my laptop just to see it. And I'm not a IT professional. I'm not a computer scientist. But everything I look at here looks pretty innocuous. The emails that are listed are sfgov.org emails, which are in the public domain. As a layperson, I don't see anything here that could be misused by someone receiving this information. And ultimately it is up to, these parties to basically justify their redactions rather than just hide behind a blanket statement in 6721L. So if you can get to the nitty-gritty of this and take a look at that one image there and tell us a little bit about it, and if anything jumps out to you as being sensitive or a threat.
I would just like to ask before that is if you're familiar with these formats of these files.
I am familiar.
Okay, thank you.
So we're looking at page 351?
352.
352.
And that's 352 and 353, but 352 to start.
I think what you have referred to, right? Email addresses, right? It says attendees to 2. I don't think that is. I don't think Mr. Henkel was referring to that. That is the same information that is available in the actual view of the calendar. The other metadata is of a more sensitive nature. It is not a human readable text. Those are specific tags that were created by the program to tag specific versions of the program, to tag how Microsoft actually sends the program, creates the files or sends the calendars, right?
Can you be specific?
So if you look at, for example, the Microsoft version, Outlook version, I think that's, well, it's not.
Why would that be of any kind of sensitivity?
So the city, for example, and it's not just the city, has different versions of Microsoft. Some Microsoft versions may be susceptible to vulnerabilities or cyber attacks because of the level that the computer or the particular person is using the Outlook. There may be very good reasons for them to use a particular version that might remain susceptible. We do not necessarily want to release that information.
Wouldn't that then be redactable?
So if what you're saying is that if all the machine kind of metadata that is all machine generated, right, that it is not specific to the human readable format that starts with attendee, I don't think I can speak to whether that could be redactable or not. I would refer that to our folks who are actually doing this work. I don't
but
run into that.
I thought you said you were familiar with this format.
I am familiar with this format. So in terms of what could be redacted or not, I think I will.
You just gave an example. If you
Right.
said if you feel that the version number is sensitive,
Yeah.
couldn't that just be redacted and the file just be saved?
My concern is that information is redacted. It might very well be redactable in the way that it's printed. So
If this was a regular text file, a .txt file, most basic of
Right.
all files,
right.
and something's redacted in there and then you saved it back, what's the difference between that and this?
I don't think if we remove all of the metadata that does not appear in the regular calendar invite, then we remove the security risk to releasing the data.
So then here's the ICS file, redact what you need to. And the city should have specialists and people to help them do that. I mean, if they think this is so important that not to release it, and they're not willing to redact it, I don't understand. We have a whole IT department here. We're paying you to do this work. I don't understand what cybersecurity is to the city then, if there isn't if there are extraordinary circumstances to redact such things.
I can't necessarily. It sounds like was that a question or just kind of?
Well, it is a question. I don't understand why this document in its ICS format that can be opened up in the same program as, say, in Windows Notepad.
Right.
Okay, and you'll see everything that's in there as it's shown on the page here.
So
Okay.
I have two comments to that.
Yeah.
First, if we open a different program and redact it, it will not be in ICS format. You will not be able to then use Outlook to go back and actually use that. So,
Who says?
well, we've tried it, and it's not re-importable, right? You export it and you change it. Outlook can't read it because of all the metadata.
You can import an ICS file into Outlook.
Right. So if you open it in text and you change the parameters, it won't be. You can't. You know.
You're not changing the
resave
parameters.
those.
You're changing the metadata. You're not changing the actual fields.
It
You're
won't be
changing the
re-
information that's in the fields.
So it won't be re-importable back. But I think there's a bigger question.
You'll
and
have to
I
prove
can't-
that one to me
Right.
because I'm not necessarily in agreement with that.
The bigger question, and I can't answer that question. I think it's a question for you. If you leave the information that is exactly available in the actual calendar invite, and you move everything that is not available in the actual calendar invite, are we asking then the city to do more work for no gain and visibility of any responder, right? If the same information of the two attendees, you know, the email is available in printing of the actual calendar invite, and remove all the other pieces, then are we asking for something that is usable?
But
I
why
can't
would
answer
you
that.
need to remove all of the metadata?
Member Joshua.
I mean, there's. Sorry?
No, I'm just announcing who is speaking.
Why would you need to remove all of the metadata? Like, for example, Pacific Standard Time. I think that it's hard to make a case that what time zone the mayor is in for a meeting is something that needs to be redacted. The version of Outlook that the city is using is not something that needs to be redacted.
We would argue that it is something that needs to be redacted because that could be used to increase the risk of a cyber attack.
Okay, well, then the citation of law to support that reason would have to be provided under the Sunshine Ordinance.
And just to ask further, like on that first page, on 352, of those first 20 lines or so, how much would you want to redact? Just to kind of get an idea of what you consider.
Well, we can certainly go line by line. I would say that.
So the Outlook version, okay, we've talked
Right.
about that version too.
So I mean, I will. The lines are not numbered, but if you
Right.
follow me, we will walk through that. Right.
Sure.
Line 1 we would redact. Line 2 we would redact. Line 3, line 4, line 5, line 6, line 7, line 8, line 9, line 10, line 11, line 12, line 13.
That you would redact?
We would redact.
Keep going.
I think I'm at line 13. Line 14, I think it starts with begin. So
Begin
obviously
daylight.
begin daylight.
Yeah.
We would leave that. The next one, the date start, we would leave that. That's available in the calendar invite. The year and the date in months, we'd leave that. I think the next ones are two time items. We would leave that. Again, end date light, we would leave that. Time zone would leave that. Would leave the begin, and then everything that's attached
Is out.
we would want to redact, and then leave
All
the attendees.
Okay.
So
that's-
what you're left with, as I can see this from this example, is the time, which is available in the calendar invite, the time zone, which is available in the calendar invite, the to, which is available in the calendar invite, and the from, that's available in the calendar invite. So all the information that would be available to the anonymous would be in the calendar invite.
Okay,
that
and
the
your
city
position is that
providing.
all those lines you quoted would potentially pose a risk to the government system. That's why you would redact those. Okay.
That's correct.
All right. Could I ask
May I
a question?
respond?
Yes, anonymous. If you could respond to those points.
Yes. So what I'm sorry, I didn't catch your name, but what the chief of security is discussing is what is known as user agent information. And so that is line 2 called prod ID : blah, 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 Outlook 16.0. And that kind of information is disclosed every time you send communications between your Outlook and somebody else's, including outside of the city. But even that, I don't care. You want to redact prod ID : whatever, fine. But everything else they told you is wrong. You can't redact the word begin V time zone on the basis of information security. I'll tell you what that is. That is the beginning of a structure in this file that defines when the daylight savings times changes in the state of California, where we are. Nothing about begin V time zone, TZID, Pacific Standard Time. BT start is a timestamp of the exact time when we roll over between standard and daylight savings time. There's nothing about these lines, even if you were to concede, and I won't, but let's say you could imagine that the user agent was a security-sensitive information. These other lines that they have cited, there's nothing security-sensitive about the fact that daylight savings times occurs once every year on RR rule frequency equals yearly, right? There's nothing security sensitive about that. So, and also I would argue attachments are public records. If you attach a PDF to your calendar invite, it is absolutely a public record unless something inside that PDF is specifically exempt. So I understand they might delete the attached : encoding because actually in this case, I would agree with them. That would be hard to understand. They can just delete that line. And they are wrong also that if you deleted that line, I would not be able to analyze this file. That's not true. You could delete all the attachments and then provide those attachments separate in their native electronic format, as they must also do. And I would still be able to use standardized computer software to analyze ICS files. I want to make sure I didn't miss anything that they argued. Yes, and you can do the same thing. You can do the same thing on page 353. And that one is really important because something that is not security sensitive is exactly when someone came up with the idea for a meeting invite and when they modified it. That is information you will never see on the face of the record on page 351. There's no way you can print it to show me that information. But in the ICS version, you can see on page 353 creation and modification date timestamps. That kind of information is critical to the public interest. Because, for example, let's say a politician does something controversial, and we want to know whether they set up that meeting invite before or after the furor in the public occurred or in the news media. This is the kind of information. I don't care what user agent the city is using. What I do care is about this kind of information, like exact timestamps, which has nothing to do with computer security or law enforcement security, that I can see here. I can see how important the mayor finds a particular meeting, as you can see on page 353, and how they've categorized it. That information has nothing to do with information security. And if they want to delete some user agent information, and if for some bizarre reason there were IP addresses or private certificate information stored in here and they want to delete that, go for it. Just declare it and give me the rest of the information.
Okay, Anonymous, I had one more question for you.
Yes,
playing devil's advocate here. Let's say we go with I'm sorry, your name again was?
Mike.
Mike's proposition that, well, if we're going to provide all the information in a redactable format in a PDF.text format, why should we then have to repeat all that work and do it in the ICS version? If we accept, this is based on the premise that we accept that their redactions are justified, which we haven't made a decision on. But if we accept that, is that a reasonable position in your eyes?
I need to clarify your question, so I don't mean to pose you a question, but I do need a clarification.
Go ahead.
Are you accepting that all information that is not visible on page 351 would be redacted, every single item, or there might be some that wouldn't be redacted? Which is the hypothetical you're posing?
Right. So if the information you were going to get was tantamount to what you see on 351, would they then have to go through and give it to you in ICS format redacted as well?
Okay, so let me, there are two answers. First is the legal one, which I think is very clear. The answer is yes. Because I requested it in ICS format, they must provide it. Now, in a practicality question, I would still probably pursue the case, because to me this is a matter of principle. Now, and I don't believe there's anything in the law that says, well, if the format is very similar after redaction to this other format, you can provide the poorer format, if that makes sense. Did that answer your question? Sorry.
Yep. No, it did. That's good. I just wanted to kind of put it out there. Thank you.
Member Yankee.
Quick question for Anonymous, kind of piggybacking on what you're just talking about. I just want to be clear. So the image on 351, which is more of like an image file versus the ICS, like, for example, I believe you stated that like the modification timestamp that's on one of the lines on page 353, for example, would not be viewable if you were just to receive what's on page 351. Is that correct?
Yes, if they take a screenshot of the Microsoft Outlook item details window of each item,
Right.
I would not have the modification timestamp, and I believe there's some other like attachments and some other.
Right. So that might be a good reason why you would very well want the ICS versus what you're showing on 351. Is that correct?
Absolutely.
Okay.
Yeah.
Anybody else? Member Kate? No? Member LaHood?
So I have a question about, so if the ICS.
Who's the question to?
Oh, this is to Anonymous. Actually, I think this is to Anonymous. If the ICS file was redacted so that emails were removed, in order for the ICS file to work, if it were re-imported, or I guess, does it matter? Would there need to be some sort of placeholder to show that something had been removed?
It would be redacted. Go ahead.
I apologize. Was your question complete?
My
Yes.
question was complete. I don't know if it was comprehensible.
Okay, so yes, it is absolutely comprehensible. It is a three-part answer to your question. So one, I don't think there's any authority for them to remove public employee email addresses from any record. These aren't private constitutional privacy email addresses. There could be some in the future, like if you're meeting with an outside person, I understand. So, but the vast majority of them should not be removed. That's part one. Part two is for people who don't understand how this file would work, they may need to. But I would actually argue that I would concede that they are not required to do additional work like putting in placeholder email addresses. I think that the law is clear. They're not required to do additional work. But in my case, because I'm a computer programmer, I can easily handle files no matter what they do to them, right? But the key part of this is any person who is not a computer programmer would be a journalist who's not an expert in computer science would be able to open this up just in Notepad, as your chair previously discussed, and look at that information that can't be seen, right? Even if the file is somehow they can't open it up in Outlook, they can open it up and print it out in Notepad and just say, hey, look what's interesting, right? Miss Marianne Thompson was invited to this meeting, or oh, look what's interesting, that the exact time they changed this meeting happened after some event, right? So even if it corrupts it, because they are not required to do additional programming, which I agree with the respondent on, even if it is not readable by Microsoft Outlook, it still has, there's a public interest in disclosing it.
Okay, maybe this is to my fellow task force members. So are we suggesting that if the ICS file was redacted, that things would be deleted, or they would be blocked out and redacted as
Blocked
we see in
out,
other files?
blocked
Okay,
out.
so you could see that there was something there
Yes.
that was no longer readable.
Yeah, it has
Thank
to be
you.
black. You have to show, yeah.
You can't
that's
just
the
delete it, because then you don't know if it ever existed.
That's right.
Got it.
So it seems like there's been a conversation or mention that the ICS would be useless if you were to change it because you couldn't, I don't think compile is the right word, but it wouldn't work in Outlook anymore. And I'm hearing from Anonymous that he doesn't care if the ICS file still is compatible with Outlook. He's looking for the data to harvest through whatever means he has to sift through this large file with all of these sort of pegs of what the data is. Is that correct, Anonymous?
That is absolutely correct. But if you do what your chair says, it would still be compatible in Outlook. If you just put an X next to everything you delete, I think as long as they're not deleting the parts that are public, it should be openable in Outlook. So,
Yeah, it absolutely. If you save a text file and change the .txt to .ics, and it has all this same formatted, it will import into.
But if you go through and so they want to block
only the data, not the field. The field is a general field. There's nothing customized about the fields. Those are the words that precede the actual data. So
no, I understand that, but
okay.
let's take the prod ID line. If you get rid of the version 2.0 and you make it version X and you load Outlook, I don't think Outlook is necessarily able to load the thing without having
it'll show
the
up
version
as X.
checksum to know.
But a version will not show up in what you see on page 351.
But the version is the key for all of this data.
Mm-hmm.
What do you mean is the key?
If it's telling you what language this is in.
I understand that, but I don't think, to my knowledge, the version for the ICS file on import for Outlook, it won't make a difference.
I mean, I've never taken an
May I
ICS
respond
file
to
and
the
cut it
technical
apart.
detail?
What?
I'm not sure this particular point is not necessarily necessary, because if it wasn't importable, then the case for the security that the respondent is putting forward will be complete, because they will, if it cannot be re-imported back into Outlook, and there was some reason to do so, if what they got was the ICS file and they got the metadata and it was not transferable or importable to any other program, then you have a security measure right there. So if we're talking about whether the version is redacted or not, it doesn't really matter, because what the petitioner is asking for, he wants to see what is on the page. He's not looking to re-import it back into Outlook. He's looking to read the actual data that's in it.
Yeah, that was my point, is that whether or not it's re-importable doesn't matter. The security expert earlier spoke of how it wouldn't be re-importable. Someone said it probably would be by replacing it with redacted statements. I don't think it matters, because Anonymous, whether he's able to view it in Outlook or view it with any other automated notepad reviewer.
I don't think it's relevant, and if there was some reason, for instance, if there was certain metadata that was removed from a PDF that was sent to somebody, and then they tried to open it up in some PDF reader, and it could not be opened because they adjusted that metadata, then we'd have a different story. Because that would be a different question here. What the petitioner is looking for, from what it sounds, and correct me if I'm wrong, Anonymous, you're looking to just read the metadata. You're not looking to actually do anything necessarily with it.
I mean, I do this kind of public records research as a hobby. I would love to be able to import it into Outlook or my version of Outlook. But I want to clarify something you guys said about the version, because one of those would ruin the importability and one of them won't. There are two different lines, line 2 and line 3, on page 352. Line 2, I'm not conceding, but I could see an argument for why the number 16.0 could be redactable, or maybe in the case of the mayor, it's 15 point, or whatever it is. that number could be redacted. But the fact that they use Outlook is not secret information. And the version :2.0 is absolutely critical to having in this file. But that does not describe the version of Outlook. That describes the version of the data structure Outlook is exporting, which I requested. It can't be secret. That standard, the standard of the ICS file format, is defined in. I have given you a hyperlink down there. You can read it on Wikipedia, and these are standardized official documents. That version 2.0 isn't secret. The only thing I could possibly agree with the government of being secret is their replacement for the version 16.0. Because you might, in some world, you could argue that an unpatched version of Outlook could have more security vulnerabilities than a later.
So
but version 2.0 isn't that information.
So you're saying under RFCs that are listed at the bottom of page 352, that you could see this, take the actual metadata, the actual data away, just leaving the fields that start each line. You can go to each one of those RFCs and actually see what the lists are for each and every version of an ICS or vCalendar or ICS file. Is that correct?
I don't know if each and every version is there, but I'm looking at the Wikipedia page on my laptop right now. This is basically iCalendar version 2.0. That's all it is, or vCalendar version 2.0.
But
that isn't the version of Outlook, right? That's just the structure of the rest of the file.
Right.
Am I being clear?
Yes, but when you look at that, you can see all the first words, the fields, like the word begin, the word prod ID, product ID, the word version, method, and so on, right?
I believe, I can't guarantee that you can tell every single one of them, but what I can see is that most of them you can, and it's important, it's not just the word begin that is part of the standard, but that second word after the words begin and end are absolutely crucial to maintaining the structure of this file, like begin v time zone or begin standard. That information isn't secret, and you need to keep it in the file.
Got it. I understand.
Now, it may be the case that some of them starting with X-MS- may not be in the RFC standards, because Microsoft adds non-standard extensions to everything.
Okay. Member Martin.
Yeah, Anonymous, you want the files in ICS format, correct?
That's what I requested. Yes.
Okay, have they produced them in ICS format?
The mayor's office has produced, to my knowledge, no files in ICS format to me for this request.
Okay, so nothing's been produced and nothing's been redacted in ICS format, correct?
In ICS format, no production, no reduction, correct.
Okay, and Mike? Okay. Can you produce the calendars in ICS format?
Can the calendars be exported in ICS format?
Correct.
Technically?
Yes.
There's no technical limitation to exporting in ICS format.
So it can be done.
It can be done.
Are there any issues with producing it in ICS format, time, or?
I think I would have to refer to the folks who deal with that every day. My main concern is that whatever information is released in whatever format is being released is the information that we consider to increase the risk of the city for a cyber attack.
Well, that might be, but I don't think we're there yet. I mean, if you produce the ICS stuff, I don't doubt there's going to be stuff redacted, and then we'll be here again. But we don't know what you would redact because he hasn't received it in ICS format yet, correct?
I would have to defer to to my colleague from the mayor's office.
But it can be produced in ICS format. Whether that's burdensome or takes a long time, we don't know.
Calendar invites can be saved as an ICS file, and that yes.
It can be produced. Yeah.
The question I have is whether or not you can produce in an ICS format with redactions.
Yeah, I mean, I think that's, I mean, it'd be one thing if you produced an ICS format, printed it out, went with a Sharpie, lined out everything. I think your question's a good one, is if you can produce it all electronically with the redactions. Do you know if you can do that?
Well, you can do that in a lot of different programs.
I don't know. I really don't know.
So I think redactions make it not ICS.
So it would change the format once you implement the redactions.
It would. ICS has a very specific structure, including the headers, including the information. If we redact, the file is kind of, it's been altered, right? Then we would have to use, and I think the chair had a kind of a good explanation in terms of you'd have to open it in a different program, save it as a different file, as a different format, redact it, then save it back to the original format, which would not be original because it would be redacted. It's kind of changing its nature by redaction.
Okay.
I get that, but again, if I use the example of a PDF, if you change essential metadata that would not cause the file to open, then that person's the requester's going to be coming back here and saying, hey, they sent me some file, but it's not openable, and then we'll be asking all kinds of other questions with regards to that and asking for deeper technological analysis to find out if it was appropriate to do that. And that's what I think we're trying to figure out.
I don't think it's akin to modifying the actual file structure for PDF. I think it's akin to, and correct me if I'm wrong, if someone they could do this themselves, but if someone requested the raw HTML of a city's webpage, you could then redact pieces of that HTML file. It may not open in a browser depending on what you extracted, but you could still very much save it as a .html. And isn't the same thing true with a .ics? It's a plain text file. You could open it with a text editor, replace lines with XXXXX for anything that you wanted to withhold, and then save it in the text editor as a .ics file. It may no longer open in Outlook, and that's kind of a TBD thing to look at, but you would still have an ICS file that had been redacted of all information. Am I missing something?
I cannot disagree or find any fault with your description. The same would apply to any file which could be saved as ICS, whether it's useful or not, or if .ics, which what the file would look like, we can take a PDF file and save it in this way too.
Well, but if you open up a PDF file in a text editor, it's a bunch of nonsense that you can't read unless you read machine code or something. Right. We're talking about a plain text file. Yeah. With a format called .ics.
Wait, that is technically, that is what you've described, the steps that you've described are absolutely technically possible. You can take the ICS file, you can open it in a text reader, you can redact, then you can close the text file, you can rename it back instead of .txt extension, you can rename it as .ics extension and have a file that has
would that work for Anonymous if that's what happened?
I believe, first of all, what respondent said is not true. You don't need to do extra work of renaming extensions. I'm doing this on my computer right now. I downloaded the URL that I provided to you that is a completely published document from the city that is an ICS file. I downloaded it. I'm on a Mac. I opened it up in our version of Notepad, which is called Text Edit. I can click around in here. I can delete the number 16.0 if they don't like that number, and I can just save it. It's that easy. I don't see why it's that complicated. Why you have to go back and forth between .txt and not. I think that is a red herring. Just open the file in Notepad, put X's where you don't want me to see stuff, and give me the file.
I mean, I think Mike added an extra step that I'm aware does exist in some Windows boxes. I don't know about the current version of Windows, but the process is there. If they did that process, whether it's one step or two, would that work for your needs, Anonymous?
If they replaced the redacted information in an ICS file with X's, that would be fine until I come back to you and say, hey, these X's are improperly withheld.
Great. Awesome. Through the chair, can I speak to the person from the mayor's office?
Absolutely. Mr. Heckel?
Mr. Heckel? Henkel.
Heckel.
Sorry. So why is this process that we've just outlined not possible? or is it possible?
Well, a couple things. So there's been a lot of back and forth about whether Anonymous will accept different formats and alterations and redactions that may or may not make something importable into his own Outlook. I think this gets to the very heart of the problem. He said, I would love to import it into my own Outlook. So if we create an importable file, he can put it into his Outlook and get into all kinds of spoofing, send out invitations that look like they're coming from the mayor's calendar. Those are the risks that we've identified.
You could do the same thing with the city's website, and yet you allow the city to have a website.
Not as easily. And we don't have to increase the risk for no apparent purpose consistent with the Sunshine Ordinance. I mean, just because some things are risky doesn't mean you have to increase the risk.
So how exactly is someone going to take an ICS and spoof another Outlook account? Like, walk me through how, with an ICS, you could conceivably pull that off.
I can't walk you through it. That's my point. Is it possible? Probably.
I don't think it is.
Well, so the city respectfully just can't take the word of the requester that, well, just trust us. You just give us all hundreds of lines of machine-readable code.
But you have to explain
we won't use it
how-
for any malpurposes, and you may not understand all the risks, but
it's
just trust us.
you have to explain how the ICS document creates that risk. You can't just say, by spoofing and this could happen. You have to outline how that security threat actually exists.
Okay.
The onus is on you, and we're not convinced by what we're hearing. If you want to bring your IT guy up to say how that might happen, have him stand up here again. But right now, everything I'm hearing, you haven't satisfied that requirement.
So, respectfully, the onus is not on the city to take risks with its cybersecurity every time it responds to a document request. We've cited to specific provisions in the law, in the PRA. They're in the record, 2 different provisions. As far as that, I mean, Michael can address this as well, but my understanding is that if there's a desire to make the file, even if it's redacted or something, importable into Outlook, then it could be used to, it would appear as the mayor's Outlook calendar because it would be recreated in a native Outlook system.
But they could take the Prop G calendar and piece by piece recreate it in Outlook and have the same thing. If you're concerned about someone being able to have an installation of Outlook and say, look, I have the mayor's calendar, like whether you automate the process of bringing it into Outlook or you hire some coders in another country at 20 cents an hour, it's still possible to make the thing look like the mayor's calendar. And even if you have that, it doesn't actually pose any real security risk unless you can demonstrate how that works. Like, I guess you could also get the plans for the city hall and build a fake city hall and show the mayor a fake calendar. But yeah.
I would also contend in your response, when you're talking about compromise of security, you're citing 62539F of the CPRA. 6253.9F says, nothing in this section shall be construed to require the public agency to release an electronic record in the electronic form in which it is held by the agency if its release would jeopardize or compromise the security or integrity of the original record or of the proprietary software in which it's maintained. Don't see any proof of that in your response.
Well, we've outlined a number of concerns. The city attorney's office will repeat them. Information about versions of Outlook used, IP server addresses. I've already mentioned recurrence information for meetings that concern future events for the mayor.
That all can be redacted, not withheld.
But I thought we were talking about now providing something in a native
but that's what
ICS that could then be imported back into Outlook.
I find that what the requester wants to do with the file is irrelevant. That's up to what the requester is to do. They're just requesting the public information in a format that the law requires. What they do thereafter with it, that's up to them. If it doesn't work in some common program or some custom program, that's not of our concern. Our concern is the information public? And if it is, then it must be disclosable unless there is some other citation that allows the agency to withhold it, the actual information. Otherwise, the document must be, the record must be provided.
So 6253.9 on its face is referring to releasing the electronic record in a form in which it is held. We don't hold these records in ICS form. So already there's a conversion step that takes you out of the purview
But the Sunshine
of that rule.
But the law allows the Sunshine Ordinance to provide, it's an enhancement to provide more efficiency and more expediency. And in it, because that is the current law, it allows the requester to ask for it in any form that is easily obtainable. In Outlook, ICS is easily obtainable.
Right. We disagree that it's easily obtainable because of the security concerns and because of the redaction
That's not security,
issues.
but the security point is not production or generation.
Well, but the process of, if we have to convert first of all, every records request along these lines would require an IT professional to answer it, because I'm not equipped to convert it, and then the members were talking about rewriting lines of code to replace things with XXX. Already, that's not required. We're not required. That's creating a new record. That's not a redaction.
No, that's just redaction. That's just redaction.
Inputting X's is changing the record.
Inputting X's is
If
redaction.
you put a black line through a word, that's a redaction. You'd have to do the same thing.
That's what's commonly understood to be a redaction. I don't think the common understanding is recoding a computer file and changing the machine language.
It's a plain text file.
Let's say we misspoke. Redaction in the common parlance and practice that is used in all governments. Let's just leave it at that. That's what we're referring to here.
But how do
Okay.
you redact a .txt file?
That's my concern. I mean, we're going
You can
around in a
open-
circle.
No.
No,
please.
I'm
Let's
asking
not
about a
conflate the issue here.
.text file.
You can open a .txt file in Microsoft Word and save it back as a .txt file, and you will not lose any of the metadata.
Oh, absolutely. I'm asking if you have the lazy red dog jumped over the blue moon, and blue needs to be redacted, and you save it to a .txt. What do you put in there to keep that there was this word here and it's now redacted in a .txt file? The only way to do it is to select it
I understand,
and exit out.
I understand what you're saying. I don't believe that that's relevant, because what we're here to find out, the complaint that's being forward is that the information that was requested was not produced. And we're now getting the reasons from the respondent, however we choose to go. The question is are the documents producible, and are they public?
I mean, but there's also this assertion that they're not redactable. And I guess the other angle that I would like to see this go is when someone requests a spreadsheet that is in use by the mayor's office, and does the mayor's office use Excel for spreadsheets?
From time to time, yes.
Is there another spreadsheet software that's used instead?
I can't say for sure.
Okay. So if there's a spreadsheet in the mayor's office that is requested of you, and they ask for it in Excel format, do you turn it over in this, I guess you're calling this a live document format? Or what do you do for a request for a spreadsheet in Excel, the original format?
Mm-hmm. I mean, I think it's a case-by-case basis. I mean, sometimes you can recreate an Excel file in a PDF in which all the information is still viewable and clear, and so that's what we would do in those cases.
Well, but at the point that you take an Excel file that's more than a couple lines, a couple dozen lines in each direction, and you put it in a PDF, you've just obscured that information. If you take an Excel file that someone requests for the mayor's office, you put it in a PDF, they can no longer use that data as data, and I'm pretty sure they'd come here to complain about that. But if that's how you handle an Excel file, that is really explanatory about why we're here regarding the ICS.
No, I didn't say that. I said it's a case-by-case basis. Honestly, I can't think of examples where we were asked for a native Excel. So maybe we would provide it. It would depend on the circumstances, if it could be redacted, if there were any sensitive information in the file. But I think that's a different question from sort of the ICS issue regarding the mayor's calendar.
I want to try
May I
and
respond?
bring this portion of the hearing process to a close, because we're running well over an hour on it. If there's any other discovery or information that you need in order to
Should we allow
make a decision, now's the time to do it. Otherwise, I'm going to move to rebuttals.
So we've allowed kind of this back and forth, and I'm curious what Anonymous wanted to say when they asked. Can I respond?
Okay,
May I speak?
go
Okay.
for it. Go for it.
So what you asked about the Excel file is it's actually all these cases are going to come before your task force, because I am going through and enforcing these specific parts of law against various city agencies. You'll see them in the next few weeks. But it is very important to realize that in an Excel file, ignore all the metadata. But if you have a cell that says equals A1 plus B2, that is a writing by a city employee. That information that they wrote, that formula, is a public part of a record. And if you export it to PDF, you will withhold illegally that formula equals A1 plus B2. And that's exactly, it's a perfect analogy to the ICS. And if the city agencies do that with Excel files, we will, in fact, be here again.
Okay, Member Kate?
Yeah, just, do you know what the mayor's office does, or, I mean, other city departments in general, whenever there's litigation and metadata is requested as part of the discovery process in emails that are produced? Sometimes they're native files, sometimes they're not, different protocols, different cases. I mean, I would think that the city frequently, maybe not in every case, discloses or produces metadata connected to its emails in litigation. Do you know what, if that happens, or what the protocol is for the city in those contexts? And maybe DCA.
Microphone, please. Hold on. Microphone, please.
I don't know. I know that it's been requested multiple times, and I'm not sure how frequently it's been produced. It's been produced in some circumstances and not in others. So.
Right.
And I mean, and sometimes you can get protective orders in cases where you can't disclose things, and that could maybe potentially alleviate the concern of the security risk. I guess another question is, has someone in the mayor's office or you know, the advisors in the IT specifically looked at these particular records that were requested, and then in this instance, the metadata, and said specifically, and not like tonight, you know, we've already heard some examples tonight on these at 351. Has someone said specifically, this information could lead to a security breach specifically? That's been advised in the mayor's office?
Yeah, so just for the first question, I think Mr. Cote is going to address the practice in litigation. My understanding is there's protective orders, there's ESI stipulations that get worked out, so he can kind of speak to that. We did consult with our IT professional. We consulted with the mayor's office's IT professional. We've consulted with Mike on the concerns associated with the metadata.
And how, and to what level of specificity, I guess? I mean, is it, and I understand that, you know, as not an IT professional yourself, because I don't have the terminology and vocabulary for it either, but have they gone into detail explaining like how it could happen? Or is it just kind of, this could theoretically, you know, how real is it?
Well, I mean, I think what we've been advised is that it increases the risk, right? So it's hard to quantify how much, but it's just a question of, will this increase the likelihood or the vulnerability to a cyber attack? Could a knowledgeable sort of malicious actor use the information for a spoofing or for some kind of data breach? I mean, Mr. Cote will kind of speak to, you know.
But that can be proven because it's technology.
Well, sorry.
But couldn't also, and I mean, this is, I guess, kind of to, because it could be proven, and it could be, I mean, but the point is couldn't it, and I guess we kind of talked around this, I guess, and mentioned it directly. It is possible, it's just an issue of kind of, do we have the people, kind of a burden kind of a question, it sounds like. It's possible to get the metadata in some form that is not implicating those concerns to the respondent in this case, and then future respondents who ask for metadata, right? I mean, that's possible, and whether it's a pain or requires different staffing than may currently exist. But it's possible to give the metadata that does not implicate security concerns, right?
Well, I mean, I think you would be redacting some of the metadata.
Sure. No, I mean, and I
so
take that
you
as a
wouldn't be
given.
giving all the
So
metadata.
I'm taking it as a given that, and which I don't know that I necessarily do or don't, but taking it as a given that some metadata could implicate security concerns that could possibly warrant proper redactions under the CPRA and under the Sunshine Ordinance. There's still some metadata that does not implicate those security concerns, is far more from what I'm understanding, and that can be somehow in some way disclosed to a requester. I mean, you'd redact other aspects of the metadata that does trigger exceptions, but the other metadata that does not trigger exceptions could and should be produced.
Let me just ask a practical question. Anonymous requested items between April 28th and May 4th. So we're talking about, what, a week? It's not a whole lot of data. It's not a whole lot of entries, including a weekend, which is not business, or could be business, but it's not a whole lot of entries. I don't see what the kind of the mountain to climb here with regards to that.
Can I respond to that?
Sure.
So it's in Anonymous's submission, but he sent something like 10 requests to the mayor's office in the span of the last month for emails and from different custodians across different platforms, potentially hundreds of pages. So, I mean, yeah, in this case, there was a week of calendar entries, but he's requested metadata for all of his requests, which are a lot more voluminous taken together, and we may be hearing about that in the future.
Okay, but we go on a case-by-case basis. This one is for April 28th and May 4th. It's not voluminous.
Right, but it still would require the essentially an IT professional to respond in a way that there's the burden in consulting with the IT professional, which we don't think is required under the law for each public records request, because you're talking about having someone who's essentially a computer expert vetting, dozens of lines of code to determine whether there's a risk. So, I mean, things can technically be done, and there's a question of burden and practicality, and we just don't. Given the risk and the burden posed, we don't view it as required.
Okay. Anything else for discovery? Should we move to rebuttals? Okay. Mr. Heckel, you have 3 minutes for rebuttals.
Okay. So I guess my just to recap, I understand there is a burden on the city of reasonable work and diligence in responding to Sunshine requests, and we certainly take that seriously, and we make all efforts to provide requesters with the substantive information that they've sought. But we don't agree that all of the onus, all of the burden, all of the risk is on the city's shoulders to just basically trust that releasing reams of code and sensitive metadata, which includes information about users' IP addresses, security protocols, et cetera, that we have to just sort of bear the risk and sort of cross our fingers when we produce that there's no concern. And I think the Anonymous said something troubling. It's actually in his PowerPoint in response to the city attorney's request. It's on page 9 of that PowerPoint. He says that he's talking about some emails are not information security records, and he points out examples that are information security records, like network firewall rules, lists of passwords, et cetera. And then he says, and possibly certain header values. Well, he's not even identifying which header values pose a risk. So if he's not doing it, then why should the burden be on us? We may not know all the risks raised by all of those headers. So our position is, when you weigh this, it's just increasing the risk into a level that's not acceptable, and it's within the security exemptions that we've cited to withhold the information requested.
Is that it, Mr. Heckel? Are you? Yes. Because there's still time. Nope, okay. Okay. Anonymous, you have 3 minutes for rebuttal.
Yes, sir. So I would like to draw your attention to pages 354 and 355 of the record. I am very specific in the violations I would like you to find and the reasons for each of those. I'm not going to repeat. You guys are very familiar with Section 67 of the Admin Code, but I would, like you to look at page 355. Now, there's reasonable people can differ about exactly which metadata is or isn't security sensitive. But there's the first most important thing that I would ask you that you find, that these calendars that weren't called Prop G, Mayor are in fact public. The mayor has already released them, but please do find that in your order of determination, because there could be some other non-Prop G calendars that haven't yet been disclosed to us. Second, I would ask that you find that they must be disclosed in the ICS format, even if they wanted to redact certain portions of that as we've described, and justify each and every single redaction as is required under the Sunshine Ordinance. And finally, regardless of how you find on number 2 regarding the ICS format, I would ask that you find that the individual items, data, and metadata, whether that's page 351, 352, 353, whatever portion, or I would say all of that information should be disclosed, it must be disclosed. They said they took this seriously, but I would argue they didn't. They did not provide that non-Prop G calendar until September 6th, and there was absolutely no legal excuse to do so. And when they provided it on September 6th, they cut off the most basic information, like location, addresses of meetings that aren't withheld normally. They could have provided me even printouts. They didn't. And I would argue, yes, now they have a lot of requests from me. But when I first made these requests, they were in early May. They had very few requests from me. The reason they have so many requests from me now is they're just piling up. So please, I would have you, if you can, read the sections of the Sunshine Ordinance into the record before you vote, because they're very clear, 67.21, 67.26, and 67.2L. And I ask that you find all of these violations. Thank you very much.
Okay, members. Motion. I'd like to offer us this. This is a guide that's provided by the League of California Cities. Now, I'm not much on guides because they're usually interpretation, but I think this is kind of an important statement that they make, because they're speaking to all California cities with regards to various different things. This particular publication is called The People's Business, A Guide to the California Public Records Act, revised April 2017 by the League of California Cities. And this is what I use to prepare for this particular case. And on page 14 of that, under Chapter 2, which is titled The Basics, there is a whole section on metadata. And I'd like to read that into the record. Electronic records may include, quote, metadata, unquote, or data about data contained in a record that is not visible in the text. For example, metadata may describe how, when, or by whom particular data was collected, and contain information about document authors, other documents, or commentary or notes. No provision of the PRA expressly addresses metadata, and there are no reported court opinions in California considering whether or to the extent to which metadata is subject to disclosure. Evolving law in other jurisdictions has held that local agency metadata is a public record, subject to disclosure unless an exemption applies, period. There are no reported California court opinions providing guidance on whether agencies have a duty to disclose metadata when an electronic record contains exempt information that cannot be reasonably segregated without compromising the record's integrity. They go on to provide a practice tip, which says, agencies that receive requests for metadata or requests for records that include metadata should treat the requests the same way they treat all other requests for electronic information and disclose non-exempt metadata. So, is there more discussion leading to a motion?
Just one quick point. I mean, this is obviously an evolving area of technology. I think it's the time today is well spent. I think the respondent's going to have to do some digging and training and retraining of people that handle records requests, whether it's a sit down with the IT person. I think this is just the beginning of this process. We haven't really heard about exemptions. We've heard about security. And that's not covered under what we're looking at, nor under what the chair just read. So I think until and when they can provide more compelling reasons, and I haven't heard them myself today, I think this is pretty clear cut.
I just want to add also, there was a footnote contained in here specifically to the sentence, evolving law in other jurisdictions has held local agency metadata is a public record subject to disclosure unless an exemption applies. And they cite Lake versus City of Phoenix in 2009, O'Neill versus City of Shoreline in 2010, and Irwin versus Onondaga County in 2010, if that is meaningful. How should we dispense with this, folks? Member Martin?
Well, I think if someone requests something in a producible format, they should be able to get it. If it's difficult to produce, maybe that's something for compliance to go over with the respondent. I mean, that's where I would start. I think he wants it in a certain format that I don't think is unproducible. I mean, it might be a question of how to redact it, like we've talked earlier. I mean, I tend to think if you actually change the text of the document, you're changing the document itself rather than just redacting something. But I don't know. But I think if he's requesting in a certain format and it's producible, then he should get it in that format. It is a little disturbing that he didn't get the other mayor's calendar until, roughly a little less than a month ago, especially if requested calendars not specific to Prop G and the request, which I don't recall. But that's the only place I can start.
Well, let's start with, we know the documents are public.
Right.
Okay? Did he receive the documents as requested?
No.
Okay.
So that would be 6725.
So you can start with the most basic aspect, and then figure in the respondents, the response from the respondents as to whether their response applies appropriately to their assertion to withhold.
Sounds like the beginning of a motion.
Well, yeah, I mean, I think then, there's a violation where they did not produce the documents in the requested ICS format. It's readily producible. I think the part I think that's bothering me is that if their response is, we didn't produce it because we couldn't redact it, but we haven't seen any redactions, so nothing's been produced. I think that's kind of what we've been talking about the last hour.
Right. Their claim is that by producing the file at all is a security risk. And the question is at the information that they have provided as their reason for not producing it, what does that compel? Does it compel you to agree? Does it compel to you to disagree?
Well, that's where I'm struggling, because I'm not an expert in this area. I don't know. I mean,
What more do you feel that you need more information in order to make a decision?
I don't even know if more information for me would help at this point. I think, they're asserting that it's burdensome to produce. They can't redact it. I don't know I still think if they can produce it, they either have to show how they can't redact it, or something like that, or maybe they can. But I don't think that step has been done yet. It's like, oh, we tried to do ICS, and this is the problems we ran into. That I think is what is missing here. To say, simply can't do it, I don't think that really works.
Okay. Vice Chair.
A couple years ago, we dealt with a requester asking for a video that the city agency was seeking to redact part of, and they said we can't redact it because we don't have any video editing software. And I don't have the case in front of me, but I don't recall us deciding that, oh, well, that's an unredactable document. It's my understanding that if there's a document that can be produced, you have to figure out a way to secure the secure parts in order to turn over a public document, because every document is a public document. And to me, it seems like we should order this document as a public document, require the mayor's office to turn it over in the ICS format, however they choose to slash through it. There's certainly ways to do that. We've talked about a few of them, and to find probably the violations, at least the first 3 outlined by Anonymous on page 354.
I'll give it another couple of minutes, and I'm going to call for a continuance. Go
Yeah.
ahead.
The only, I think it's pretty clear that under 6721L that these are public records. I think that the requester can request them in the format that's easily generated. I tried to do this. It took me all of 5 seconds to make an ICS file, right? So I think we're on how do we redact it, right? I don't think that we've even seen an example of how this would be burdensome. They've just said, no, we just can't do it, right? So absent that, I think they need to show a redacted version. And like you said, it's a week's worth. We can't look at, he made 100 other requests, right? This one, I can't see how this somehow meets to the standard of we just can't produce the record. So at a minimum, I would move then that there's a violation of 6721L.
Okay, moved by Member Yankee.
That would be 6721
L.
L for not providing the
That
document.
would be, right, not providing electronic, the public information stored in electronic form shall be made available to the person requesting the information in any form requested which is available to or easily generated by the department. I'm not sure if anyone else wants to add additional, but that gives us the starting place.
I mean,
Debate.
one of the, I think I don't say low-hanging fruit, but I mean, the production of the non-Prop G calendar took several months. I think that's, as the mayor's office acknowledges, it is a public record. I think the delay in getting that is a violation of the ordinance, 6721, as well as, I don't know about 6726. That's more about withholding kept to a minimum, which I do think applies to this, because I do think that there is a way that the metadata that does not implicate security concerns There is a way it can be produced. I'm confident, and that it should have been produced, and it should be produced. And if there are security concerns in some of the fields in the metadata, the content of the fields, but not the field descriptions themselves, the mayor's office can redact those, and citing the reasons why. That's not happened, and I think the failure to do that is a violation, I would think, of 6726, which requires withholding to be kept to a minimum. I think there's no dispute that metadata is generally public, as the chair has, described from the kind of the prevailing thought on some of the guidance that's out there to municipalities and counties in California. Metadata is a public record. Some of it may be exempt, but I think we can all agree, and I think it's clear that some of the metadata at issue in this complaint was not exempt and has not been produced. And so I think a 6726, if Member Yankee might consider amending to add that as a violation, and 27 as well, on the failure to justify withholding the non-Prop G calendars until they were, eventually produced. I think 6726 and 6727 are also implicated and violated here.
I would agree. So I would, include those as well.
Okay.
I'd second.
I also, so did the second, who's the, I think you were the second. Okay, great. I also want to add that there is also Prop 59 from 2004, which was a constitutional amendment, I believe, that basically says, shall the Constitution be amended to include public's right of access to meetings of government bodies and writings of government officials while preserving specific constitutional rights and retaining existing exclusion for certain meetings and records. And the voters approved that by 83.4%. And so I think that's also was significant because post the Sunshine Ordinance being created, this was kind of the first public records, significant public records amendment to strengthen the Public Records Act. I'd also like to note that it was approved for the ballot unanimously by both houses, the Assembly and the Senate. There wasn't one no vote. And I find that, very compelling, and it's very core and basic to the work we do here with regards to calendars. It was very core and significant when previous cases regarding public officials and the mayor had requests for calendars in whatever format was requested at the time. So I just wanted to add that for the record. Okay, any other debate? Any public comment?
On the motion?
No, your party. Okay, seeing no public comment, please call roll.
On the motion to find a violation of 67.21L, 67.26, and 67.27, Member Yankee.
Aye.
Yankee, aye. Member Kate.
Aye.
Kate, aye. Member Martin.
Aye.
Martin, aye. Vice Chair Wolf.
Aye.
Wolf, aye. Tesfa, absent. Kanata, absent. Member LaHood.
Aye.
LaHood, aye. Hinsey, absent. Member Highland.
Aye.
Highland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay. We need to call general public comment.
Yes. Next on the agenda is item number 6, public comment. Members of the public may address the Sunshine Ordinance Task Force on members within the committee's jurisdiction, on the task force jurisdiction, but not on today's agenda.
Any public comment? Please step forward.
My name's Robert M. Smith, and I'm here just to say 4 brief things. 1, thank you for your hard work in file numbers 18049, 083, and 19058. 2, I would ask you to issue the third order of determination against the museums which I haven't received, but you voted unanimously to do that. I just haven't gotten it. 3, to ask you to send those files now to the district attorney, the ethics commission, and the board of supervisors. At some point, one has to say enough is enough. 4, finally, please read my report titled Case of Freedom in Quotes of Information in San Francisco at pages 848-852 of your record for tonight. It's really just 2 pages, a little bit more, because 2 pages are illustrations, which, somewhat hilariously, are the current marketing campaigns of the museum, or at least of the de Young. And they say that there's a button that says, your city, your museum. There's a broadside that says, your city, your museum. And if I have enough remaining time here, I would just like to read the paragraph summation of what I've referred to you, which is in tonight's record, and I'll stop with that. This city department, that's what it is, has thus far managed to shield public documents from public view, unlawfully delay making public what is compelled to make public, censor with heavy black markers what it wishes, complain of a lack of resources to comply with the Freedom of Information statute despite its many millions of dollars, plead that its records are in fact private, and claim that it was counseled on this by the city attorney. Most importantly, perhaps the museums claim the law permits them to withhold from public scrutiny any documents they wish without identifying the documents or even saying the documents exist. Incredibly, this conduct has now been going on for 1.25 years. Honorable members of the task force, I have at the end only one question, and you'll forgive me, but I must put it. Do you intend to tolerate this undemocratic, no anti-democratic conduct from a city department in this American, purportedly progressive city? You have thus far issued, or will have issued, 3 orders of determination. 3, that the museums have violated the law in 3 separate instances. This is taking place under your jurisdiction, folks, and on your watch. Thank you.
Any other public comment? Seeing no other public comment is closed. Let's call the next item.
Item number 8, file number 19044, complaint filed by Anonymous against Dennis Herrera in Office of the City Attorney for allegedly violating Administrative Code, Section 67.21, 67.26, 67.27, Government Code Section 6253, 6253.9, and 6255 by failing to respond to a public records request in a timely and/or complete manner.
Okay. Complaint committee?
Anonymous, you have 5 minutes.
Oh, wait a minute.
sorry,
I was
my
asking for
apologies.
Yeah, sorry, I thought you said complainant for that. So this is,
complaint committee.
and the complainant can correct me if I'm wrong, but this is metadata without the calendar issues. So I think it's a lot of this, some overlap from the previous item, but it was heard the same day. I think same complainant. So.
Okay. Anonymous, you have 5 minutes.
Thank you very much, and thank you for your determination of a violation in the prior case. I look forward to the order of determination as soon as is practicable. I am also the anonymous complainant in case 19044 versus the Office of the City Attorney. I had a long speech, but I'm not going to go through it because it's really not necessary. What's important is page 530 of your packet. In this case, we have 2 possible formats that I have offered to the Office of the City Attorney, .msg and .eml. Both of those formats have been regularly produced by other city agencies, and they're published online for all to see. Again, we're going to have the PDF issue here. I'm not going to go over it again. They're going to be email metadata and headers, and I'm going to ask you to find the same exact thing, that in general, headers cannot be just broadly exempt from disclosure, but instead the specific headers that they would like to argue are security, privilege, or privacy related, they can redact those only. And there's also an extra issue here, which is that the respondent happens to also be the supervisor of records, and they failed to provide a determination when I made a petition regarding this case under 67.21D within 10 days. Instead, for this case, they took over 100 days to provide a legal determination. So I'd like you to go to page 531, and I'm sure you may have plenty of questions about how email works, because this is going to be actually a more complicated case than the last one. I made an IDR for 2 specific emails in specified native formats with all metadata and headers. They provided a PDF printout of those emails without any justification for withholding the headers and metadata. Then much later, beyond the 10 plus 14 day deadline, even with all extensions, they provided one of those 2 emails in header format, but with nearly all of it redacted and in a strangely image PDF format of those headers, which is very odd. You'll see it later. Now, the way email works is when you send an email, it goes to a variety of servers in between, and each of those servers adds or removes certain headers or metadata, and it tells you that it is transmitted through those servers, and importantly, when it did. And because of that, the copy that the recipient receives is different than the copy of the record the sender has. On the next page, I'm going to show you a case study of a specific email already released in a completely unredacted format, in PDF format by the Department of Public Works online. And this is my conversion of their MSG format to PDF format. This is similar to how the city attorney currently releases emails. You can't see the address of email, the public SSGov email addresses of the from and to, and a lot of other information, as you'll see on page 533, is withheld. Now, I want to be very clear what I'm showing you here. This is a portion of a completely unredacted record released by the city. I voluntarily added certain blackouts to this slide, but the city has already fully determined this to be a public record and released it. Now, the information on this is the very common kind of information, like the from and to and subject, with the email addresses, which is absolutely public information. But there's also some other information, like host name, IP addresses, which I have partially blocked out here, and importantly, timestamp of when people sent and received emails. That timestamp is absolutely public information. It also gives you identifiers for each email, and those allow you to correlate different emails to figure out what the thread of replies and forwards were. If you go to the next slide, it actually blacked out most of this. Most of what I've blacked out, even though the city completely publicly provided it, is non-standard email headers. And you'll also see there is an IP address, because in this case, emails, unlike what I can see in calendar records, they do appear to have IP addresses. However, the city releases that IP address every time they send an email to someone else. That's just how email works, and I'm sure that your cybersecurity expert can discuss this in more detail. If you go to the next slide on page 535, you'll see MSG and email formats are easily generated, and my offer to the respondent is they may wish to use EML formats because they are a standardized, almost plain text format, just like the ICS format earlier. MSG, I believe, is a proprietary Microsoft format, and you may not be able to redact that as easily. However, the city already releases hundreds of MSG emails. In fact, one agency released 200 raw emails regarding the custodians working group in 2 days of receiving my request. As you see on the next slide, which Mr. Heckel alluded to, email headers aren't completely exempt. Maybe they'll argue that some specific ones are exempt, and they can do that. But currently, they're not even providing the names of the withheld email headers. There's no argument for withholding that information. And most importantly, not even the common information you would see in Outlook, like from, to, CC, BCC, if they're secretly sending emails, is being shown to me. They must release that. And as I said, whenever you send emails to the public, they get most of this information. What you can see on page 537
Anonymous,
is a sample of their supplementary disclosure.
Excuse me, Anonymous, your time is up. Can you please finish your sentence?
I would just say look at page 537. At the very minimum, the names of those headers must be released. Thank you.
Any persons or witnesses provide any facts or evidence on behalf of the petitioner or the complainant? Seeing none, respondent, you have 5 minutes.
Good evening, task force members. John Cote. I'm the communications director for the city attorney's office. First, just a housekeeping item. This anonymous complainant raised the question of whether the supervisor of records must provide a determination within 10 days. That issue is not before you today. That is the subject of a separate complaint that is not on tonight's agenda, so it will be dealt with separately on another day. So now to the issues before you. I'd first refer you to our written response of May 17th. I believe you'll find that on page 757 of your packet. It lays out our position clearly. I will also highlight a few points. First, as you know, this is not about documents. We provided the documents that the complainant requested. This is about machine language, also known as metadata, that reflects the inner workings of our computer systems. Now, this information is created automatically by our system rather than by a city employee and the course and scope of their work. It's not even visible to the average user inside the city unless they are a trained IT professional or they've been trained on how to access it. Now, turning over metadata can subject the city to security risks and can lead to the inadvertent disclosure of privileged information. So that is why generally we don't produce it, except sometimes, if necessary, in litigation, and even then, only if there was a protective order to safeguard against the info being misused or disseminated to others. Additionally, even in litigation, we have never turned over our email headers. Here, we have turned over the metadata that our IT experts feel is safe to produce. Now, the Public Records Act expressly provides two different exemptions that are relevant to the electronic records that we're talking about today. You had mentioned earlier section 6253.9F, which provides an exemption for records in electronic formats if it would jeopardize or compromise the security or integrity of the original records or of any proprietary software in which they are maintained. Additionally, there is another exception, which is 6254.19, and that exempts from disclosure an information security record if, on the facts of the particular case, disclosure would reveal vulnerabilities to or otherwise increase the potential for an attack on an information technology system of a public agency. That is what we have here. So consistent with these exemptions, we have determined that disclosing the metadata still being sought in this matter would pose an IT security risk. We are relying on the expertise of our IT professionals who have indicated that disclosure of the native files and additional metadata poses a risk to our systems. Now, email metadata can disclose or lead to the discovery of all kinds of sensitive information, such as the unique identifiers for individual computer terminals or computer servers, commonly known as IP addresses, and other security-related information. That includes what kind of virus protection we're using, what kind of internet or network routing we're using, or what versions of software we are using. So this information is highly sensitive, even in isolation, but it's especially sensitive when you put it all together in this context. So this is not a knee-jerk reaction. Our IT experts have looked at this very carefully, and we've released additional metadata that they concluded was safe to release in this case. But they've concluded that disclosing any further metadata would expose a vulnerability or possibly even lead to an attack. For example, it could allow a hacker to penetrate our system or spoof our emails or insert themselves into attorney-client discussions or send unauthorized emails purporting to be from city officials or staff. So providing emails in native format would allow the requester to open up an email and change it, manipulate it, and respond to it, and it would appear like it was coming from the original sender. For example, someone with the information being requested could mimic an email so that it looked like it was one coming from someone in our office, but instead was embedded with malware, like a ransomware. And these are not merely hypothetical fears. Both our office specifically and the city more broadly get cyber attacked on a regular basis. Given what we know about metadata and the tremendous risks involved, our assessment that further disclosure poses a security risk is reasonable. And it's not mere speculation or conjecture. So there have already been a number of cyber attacks on the city, including In July 2019, the Asian Art Museum. November of 2016, the MTA. In the early 2000s, the Board of Supervisors had individual supervisors whose emails were spoofed. And then once you broaden it past the city of San Francisco, just last month, September of 2019, had the city of Livermore, where their staff determined that a virus started sending unauthorized email from city staff accounts to residents. That same month in Union City, online services like payments, licensing, and permitting were all shut down, as was the city staff email system. In April of 2019, you had Imperial County, where the county's government website was down for 6 days as a result of an infection from the Ryuk ransomware. That included affecting their online payment system through the Treasurer and Tax Collector's Office, as well as the County Department of Social Services. And an even more disturbing example, in June of 2019, Riviera Beach, Florida, someone in the police department opened a malicious email attachment that eventually locked files and shut down all of the city's services, causing more than $1.5 million in damages so far. Now, after more than 3 weeks in that circumstance, no computer systems were working properly, crippling government services. During the past 2 years, there have been more than 50 cities across the U.S. that have been victims of ransomware attacks. That includes Atlanta, Baltimore, Greenville, North Carolina, Albany, New York, Cleveland, and Ohio. We don't want to be on that list. And I'm happy to answer any questions you may have.
We'll get through the rest of our process, then we'll ask.
Okay, sure.
Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Seeing none, members? Vice Chair Wolf.
So I don't know where we're going to end up at the end of this, but the easiest way to take an email and verify that it wasn't spoofed is by looking at the headers. You can actually see where the email originated, that it went through its process. These headers, as we heard testimony, are not viewed by members of the city in their day-to-day email activities. So if you had reason to think that maybe there had been a spoofed email interjected into the system, asking for those headers would probably be the best way to get it. We also heard a list of various attacks, cyber attacks that came in, but I don't believe any of them were mentioned as a result of email headers being made available. And so we have an issue as the last one, where there is various discussion over the security risks. And anytime you open your door and step outside, there's a risk of getting hit by a car. The question is, are these risks that they're describing the risks that you encounter walking down the sidewalk, or are they actually putting the city's data in harm's way?
I would agree with that. I haven't heard from the examples that were noted that any of them were breaches due to the release of metadata. I've heard virus, I've heard malware, hacking. That has nothing to do with metadata, and frankly, in a data file, the metadata wouldn't reveal enough information to teach anybody about how to hack, except maybe an IP address, which probably could be redacted, especially if it was on some specialized network or what have you. It doesn't, and I agree with Anonymous's examples based upon the formatting of what's visible, that in order to be able to see the email addresses for those items, you'd have to look at the headers. There's no two ways about it. And that's the purpose of revealing the metadata and why it should be, the ordinance allows for the public information to be generated in a form that's requested, so that the public information can be corroborated, determine if it was correct or not, or even whether it's valid. Maybe the city got a piece of spam, and you look at it and they could say, oh, this is really spam. It didn't really come from the government. It's not really public information. It's not information that I can use, or what have you. I think going back to what I had stated from the League of California Cities applies here even more. That just the basic of good government is to provide all the information, and if there is any concern about it, that the professionals that the city hires, either on staff or by contract, to review in general for the city its entirety, because there are always a lot of confidential information. We just had an election about privacy and what information should be held. Okay, I don't think we're leaving it up to some conjecture that of what department feels would be privacy or not. That's actually has been directed to a very high-level city staffer, namely the city administrator, to develop very specific policies around what information should be withheld or not with regards to information collected by third parties that have city contracts. So I don't think there's much to ask for here. I'm not compelled by the respondent's response. I do, Mr. Cote, I do have a question though. You cited a section of the CPRA 6254-19, is that correct?
Yes, that's correct.
6254-19, there is no 62. Oh, I'm sorry, there is. I'm sorry. I thought it went 1.1. Never mind. Okay. Okay, so let's
Any
read that
additional
into
questions?
the record. Let's read that into record. Nothing in this chapter shall be construed to require the disclosure of an information security record of a public agency. Information security record. If, on the facts of the particular case, disclosure of that record would reveal vulnerabilities to or otherwise increase the potential for an attack on an information technology system of a public agency. Nothing in this section shall be construed to limit public disclosure of records stored within an information technology system of a public agency that are not otherwise exempt from disclosure pursuant to this chapter or any other provision of law. I'm not quite sure that a calendar entry is a security record. In a
Calendar
sense.
entries aren't at issue here. We're talking about email headers.
Oh,
It's
I'm
a
sorry,
separate
but
case.
even still, email records are not a security record.
Through the chair.
Yeah.
Mr. Cote, if you could approach. So I believe, and I'm sure Anonymous will help me if I'm getting this wrong, that on page 540 we have essentially 87 things that are included in an email header. I don't know what most of those, maybe all of those are, but presumably some of those are metadata that you're concerned about the security risk, and some of those are metadata that you're not concerned about the security risk. And I would like to understand how the decision was made, what pieces of the header are a security risk and what aren't, because it sounds like you just have sort of, well, actually you turned over, you didn't turn over the headers and then you supplemented stuff. What was turned over and what wasn't from the header information?
I believe the about what was produced is available, like in the record. The determination was made by our IT professionals about what was safe and what wasn't safe to produce. We produced what was safe.
So what would be the best page to look at? There's a lot of material
I
here.
think it's 765.
765.
I think that was an attachment to the respondent's letter. I think it's 765.
Sorry, it's taking me a few minutes to thumb through 100 pages.
I guess I have a more policy-weighted question, Mr. Cote.
Certainly.
Do you have is there a general policy within the city attorney's office as to which headers are to be redacted when a public record is requested?
I would have to check and see. I can tell you that this is the first time we've had a request for metadata as a public records request. So I don't know if that policy exists or not.
But like, let's take page 765. There's just lines of black lines. Each of those lines is a different piece of data on the header, a different categorical piece of data. What was the reason for the first line?
Our IT professionals determined that it was a security risk to release it.
But what is the categorical information contained therein?
I don't know.
So, for example, like as either this document or the previous document, Anonymous said, the word social security number colon and then a space to leave it. Social security number colon doesn't need to be redacted because we all know that everyone has a social security number.
Mm-hmm.
Not all of this information is specific. Some of it is generic. And yet it's all been crossed out except for the fact that it came from a Microsoft Exchange server, the fact that it's Microsoft type email.
Let me ask you,
Yeah, go
if
ahead.
I don't mind, Mr. Cote, you know, I'm looking at my Google account, and I'm looking at the headers for the Google account. And these headers are pretty similar, and they start out the same way for every single email, whether it's from Google or Outlook or what have you. And the very first line is always delivered -to : Why was that? Now, whatever happens after that, okay, I'm not concerned with. Just the words delivered -to with colon, why was that redacted?
All the redactions that were made were determined by our IT professionals to pose a risk to our IT security, and that's why they were redacted.
Okay. Is there some policy that is common or comprehensive to your office with regards to this? I'm asking that question again. How do they know, by what rubric are they using to determine that it's a security risk? Just the header, just the label of the header. I mean, there's delivered to, there's received, there's sent, return path, there's authentication results, there's DKIM signature. I mean, there's message ID from, date, subject to. Those are publicly, that is the format that is publicly available. You can find it on Wikipedia, everywhere, no matter what. In fact, it's publicly releasable by the companies that make the software, actually. It's not, there's no security breach or concerns about it. It's the information that is on the other side of the colon that is really the big concern. So I'm just wondering why we have almost a full black page of black when, with regards to this particular message. Is there some?
As I indicated, that was the determination of our IT professionals. As far as a policy goes, one thing I can point you to is certainly the Good Government Guide, and page 102 of the Good Government Guide. I'm happy to put it up on the overhead projector if I don't know if this automatically shows up or if the clerk has to give me access to it.
We'll get it for you.
You'll note it in the relevant section in the second paragraph where it reads, there is no evidence that either the Public Records Act or the Sunshine Ordinance was intended to require public entities to search and then review and possibly redact metadata in electronic records. Neither is there an apparent legislative intent to require government agencies to produce records in their electronic format if that release would jeopardize or compromise the security or integrity of the original records or of any proprietary software in which they are maintained. Obviously, it cites the California Government Code section.
So again,
May I respond? Sorry.
Anonymous, you have to wait until we ask you a question. This is not a dialectic. I want to read back into the record for this case, 6253-9F. Nothing in this section shall be construed to require a public agency to release an electronic record in the electronic form in which it is held by the agency if its release would jeopardize or compromise the security or integrity of the original record or of any proprietary software in which it is maintained. Outlook is not proprietary software. Okay? That would be like custom software, like our new electronic voting system, that kind of thing. But the metadata, that's not what, metadata would not do that. Okay, and I'm happy to bring any professional in that could explain how it would be. I think we would be talking about code that would come from a specific file that is part of the system that may create Outlook and make Outlook work that would be proprietary to Microsoft. That's a different issue. Here we're talking about a public record that has a public format. The RFC is a public format that is accepted everywhere, every government, every email, every system internationally. So these are not files that pertain to the workability that makes software work. It's what software creates so that we can see the information that it's processing. So there's no kind of reverse engineering that could be done from it unless some professional can come up here and show us how it would be. And I think that's kind of what we're asking here.
Well, with all due respect to the chair, I would caution against that. I think in an unsecure setting like this, where you have a public forum, you're asking someone to come up and lay out a roadmap for how to like spoof a city official's email.
No, don't spin my words, please. Okay?
But that's what it
That's
sounded
not
like.
what I said.
Oh, okay. What did
I
you say?
said I would like to have somebody, a professional, come up here and show me how an email with the metadata, okay, could compromise security, okay? Because that's what we're asking here. You're claiming as part of your defense that that the information that you redacted has some security risk. Well,
that's correct.
But you have to prove that, okay? And it's not if it was the information that is like custom, that is specific to a sender or a receiver or the content of the information or the delivery of the information, that's something that we can definitely have a conversation about. But if we're talking about standardized headers that on a blank email would just be blank in those areas, some will be blank and some will not be blank. Okay, the parts that would not be blank are put in there by the program that is not necessarily, I would say comfortably, not necessarily giving up any kind of security caution at all, okay? Except maybe an IP address. Sure, that could be redacted, but that's a conversation that we can have because that is a very specific custom piece of information. But the word destination, : there's no security breach or anything I can tell that would be. So I'd like to hear from your IT folks as to that redacted this as to why they had redacted all of the lines because I'm not sure what's redacted here. And if you're telling me that what has been redacted, everything above it is of something secure, then just produce an empty email or just a generic email, and let's compare them. Just compare the headers themselves. And I'd like to hear from your IT guys how they think that would be of some sort of breach.
So 2 points on that. One is that our IT professionals determined that this information did pose a security risk in its entirety and in concert with the other information that's there. So it's not necessarily one pick and choose one little piece. It's the sum total of what that provides. And what it provides is an easier path for somebody to mimic a city email. And
So-
that's what leads to the security risk.
Okay.
And to your earlier point about the other examples that we gave of cyber attacks on other cities and claiming that none of that had any connection to email headers, we don't know that to be the case. I mean, certainly in some of those instances, in the instance of Riviera Beach, Florida, was precipitated by a police department employee opening an email. Now, one could reasonably presume that that police department employee opened that email on his city email account because he thought it came from a trusted source, but in fact it didn't, and it contained malware, and it crashed their systems.
Yeah, but that's not what the requester here is requesting.
You haven't proved
He's-
that it came through the header.
Yeah, it didn't come, it
How do
has
you know it
nothing to
didn't
do
come
with the
from the
headers. Has nothing to do with the headers.
I don't know what basis you have to say that.
I'm a security, I'm an IT professional.
Yeah.
I'm the chief information officer of the organization I work for full-time.
Okay.
So I know this stuff, okay? And like I said, it's not for me to try to prove your case or disprove your case. It's for you to convince us that there is a security issue. And that's why I'm asking for your IT professionals to show us. You need to show us. That's your defense. Otherwise, the information is, when the issue is brought before us, we start with the information is completely public and disclosable, every single piece of it. It's up to you to prove to us that it's not.
So there are exemptions that apply. We've highlighted those exemptions. Additionally, to the point of redaction, our view is that when it comes to metadata, we've already met our obligations to keep withholding it to a minimum, and that we don't need to go further and parse it word by word to see if there are additional fragments of metadata that can be released. That is not what the law says. The law, Government Code Section 6253A, is that an agency only has to produce the portions that are reasonably segregable, can reasonably be segregated out. And the metadata here is all part of the same portions of the document, and the various pieces of metadata may be intertwined with one another, and this is not as simple as redacting out the top email in an email thread.
Can you just give me that citation again? 6254?
6253A.
6253.
To the chair?
Yes.
If the email headers were such a security risk, then every time a member of the city sends out an email to a member of the public, they're releasing that security risk. So how is it okay for an email to contain this header information that gets sent to a member of the public, but it's not okay to turn this same information over to the public?
I don't know if that's if your representation there is accurate.
Like if I go to the last email I received from the SOTF from, Bruce is not on the city's email, so let's go with SOTF. I can pull up the full email that came from the city, double click on it, view the full source. Now I have whatever it is that we're supposedly trying to protect right now, and there's nothing on it that has any value to anyone that I can figure out, and it's freely being distributed. Like when I send an email to a supervisor as a reporter, I got an email back that had a header on it. That header had some information on it. What is in these headers that is the security risk?
Like I said earlier, that's the determination of our IT professionals, that this information poses a security risk if it's released, and they're not prepared to do that.
All right, thank you.
Yeah.
So, Mr. Cote, I have another question for you. I just wanted to go back to your citation 6253A, and I'd like to read that into the record. Public records are open to inspection at all times during office hours of the state or local agency, and every person has a right to inspect any public record except as herein provided. Any reasonably segregatable portion of a record shall be available for inspection by any person requesting the record after deletion of the portions that are exempted by law. You're stating that your cybersecurity folks have redacted these portions of these emails, but you haven't cited the exemption. By which exemption of law?
I did right at the beginning, Chairman, and that is 6254.19, 6254.19.
Okay, so in 19 again, okay, it says again, nothing in this chapter shall be construed to require the disclosure of an information security record of a public agency. Is an email a security record?
Yes, in our view it is.
So every email is in City, County, San Francisco is a security record? You stand by that?
Certainly these are. The ones that are...
That's not my question. My question is, you're claiming that this email is a security record. Does that mean all emails are security records?
In this case, what's before this body, the emails that are relevant to this, are security records.
Okay.
That's our view of the law.
I'd like to see a definition that an email is a security record.
I'm sorry.
Go ahead.
Didn't mean to interrupt.
Member Kate.
I think all emails and internet, it's all sorcery and magic to me, so I don't fully understand all the technical details. I believe that certainly some information, or I have reason to believe, that information that's available in metadata could somehow be used by the magic sorcerers of the dark arts of hacking to figure out how to do bad things. I just believe that. If someone can crack into my computer and watch me stare at my computer, I feel like that probably could happen if they use, the metadata could be abused in a way that we're hearing the cities expressing concern about tonight. So I think, and I think information security record wouldn't necessarily be the email in its entirety so much as certain lines of those metadata that could be exploited in that way. And I actually think that possibly information security record could be that one particular or that 18 particular types of metadata itself. Now, the content, not the header. And I think that's one of the issues that I think we've all got, or it sounds like we all having with the over redaction of the particular email that we've seen where the headers have been redacted. I don't know, and absent having like experts advising us on how the content of some of the metadata could be used and abused, and if I had information that can help me understand that, and definitively that it can never be used, then I would feel a little bit more strongly. I feel strongly enough about the redactions being overbroad, though. I think that the city's probably got 6254.19 correctly kind of cited as a general proposition that there could be information warranting redaction conceivably. I don't know in this case, and we don't know in this case because we have all of the headers redacted and we don't know what was redacted and what wasn't. But maybe there's something I'm just not missing. I'm not getting, from the tech perspective.
I think the way you started out your comment is even more relevant. You don't know. And if we are all here blind and we don't know, it's really up to them to prove it and show us how it is actually. That is very important because this will create a precedent for every other department and every other elected official with regards to emails, metadata with regards to emails. Okay? And if they are going to just claim a blanket statement that our professionals say that this is a security caution and it should be redacted, they need to show. They don't need. We're not asking them to reveal what the custom information, the actual kind of specifics of the information. The format of the headers of an email are public information in general. For every single email server, email application, I don't care where you go, you receive an email, those headers are standard. And they're standard by the reference that Anonymous put forward in some of his citations with regards to these RFCs, these references, okay,
Right.
that are created by large government and agencies, so that there is a common format, so that we're not all, you have the way everybody can speak to each other, so to speak, okay? It's that kind of, like a text file, .txt can be opened by any app, almost any word processing application. Why? Because it's a common format, and it's created that way on purpose, okay? So that's really the crux, for me, that's the crux, is it hasn't been proved for me, and it doesn't sound like it's been proved from you, from what your statement is, that they have shown, yes, I could see maybe it's excessive, but which parts of those? I want to know, like, destination that's generally it's who it's being sent to, okay? Well, if you want to redact it because it's not a government email, okay, fine. But the word destination, colon, why is that being redacted?
Right.
There's nothing cautionary about that. But I want to hear that from their experts as to why. Because that also then determines, is somebody just arbitrarily doing this? Is this actually correct? And we should be able to make that decision. And frankly, if this case was over at the Ethics Commission and going through their discovery investigative department, I think there'd be a whole lot of other questions going on with regards to whether this was correctly done or not.
Yeah.
Member Yankee.
I just wanted to add this. I think I'm pretty much the same place that Member Kate is as well. Is that I don't even think we can have a productive discussion because what I'll call them field titles. Like you said, the generic things, they're blacked out. So we can't even say, oh, line 8 looks like it may or may not be a valid redaction because we have no idea what line 8's about. Part of what I do, I oversee, an office that does actually, by law, we have to redact certain parts of documents. Strangely enough, one of them is a Social Security field. We always redact the number. We don't redact the words Social Security number. That to me seems, the fact that they're redacting that doesn't seem to be consistent with other types of California laws that call for redaction. They don't, in my experience, call for the redaction of the field title. It's the information, like you said, after the colon that gets redacted. So to me, this is an overly extensive redaction that I think at a minimum, it's like I said, it's too much redaction.
Vice Chair Wolf.
So I'm not 100% confident that you can't do something with the email headers, but I spent a lot of time Googling how to use email headers to do something and couldn't find anything except for how to identify whether or not an email's been spoofed, how to identify whether it's followed the proper tracks. And so where I'm at is that a cursory research seems to indicate that there really isn't anything of a security risk in sharing the headers. I don't know whether that is at all true or not because it's a very cursory list. But what I do know is that no one on this side of the table seems to have 100% certainty over what could and couldn't be released from a header. And to that extent, I kind of feel like we need to hear from some third-party technology consultants because we can't really go with what we're hearing from the city's representative who's chosen to redact this information. And it doesn't seem like anyone, myself included, has the full technological expertise to refute what we're hearing from the city's expert. And so that makes me feel inclined to, make a motion for their technology committee that's been in recess to sort of hash these pieces out, or maybe we move forward with the information we have, but it does make me a little nervous.
Member Island.
We haven't talked to Mike, the technical person. I'd like to know who it was that...
Is he here for this case?
Yeah, he's available.
Well, he was called, was he called in by Mr. Cote? Is he part of your case?
We requested.
As part of the history at the complaint committee, he was called for this case in particular.
This case in particular?
Correct, but he agreed to talk about the previous.
Great. Okay, thanks, I didn't know that.
And you had a question you wanted
Committee
to
members
ask.
again?
All right.
Sure.
I was going to say, go ahead and state your name.
Okay. My first time, so apologize.
Sure, that's fine.
I'm really nervous in front of you. Michael Maxman, I'm the City Chief Information Security Officer.
So, Michael, do you know who did these redactions, or were they in your department?
They were not under my department. I think they were done by the IT staff of the City Attorney Office.
Didn't you have a question about earlier?
No, because I want to hear from that staffer, the people that actually did it, because they had either they have some rubric or some policy or some guidance or some order from somebody, direction from somebody to do things in a very certain way. And I think that's what's important. I think I can ask all the generic questions I want. I think that's helpful for some of the non-tech savvy folks, but I think what's important here is if we all we're here as being not tech savvy, it's really up to the city to be able to explain to us how and why these areas or these things are redacted that are actually a security breach, and explain the breakdown of why each one is.
This is a sort of a generic, specific way to ask this. Mike, if you had access to an email header, what could you do with that information, and what, not specific vulnerability, but what technology's vulnerability would you be relying on to use an email header to do some sort of negligence that you obviously wouldn't want to do, but as this security professional, you should be trained to know how to do to stop?
Certainly. And so, generic question, probably you'll hear more generalities than specific to this particular email. So, a few things that we usually see in an email, and I think the chair, as the kind of a fellow IT professional, already mentioned them. One, we will see something similar to what we see in a calendar version, and we certainly do not want to release calendar version. That's something you would not see if I sent something to you. You wouldn't see mine necessarily calendar version. It's something that you would only see in the email requested from me. Another thing is some of the addresses of our servers, email servers, that we don't necessarily want to release that in public, right? You will see security settings of how we have configured our email system. So that's not necessarily something that you would see if we were to send email back to you.
Mm-hmm.
You would see from ours. You would see specifically if it's Microsoft email, you would see specifically Microsoft codes, right? That talk about the way that Microsoft is configured for the city specifically, and we might not want to release those as well. Obviously, the information that I see in front of me, and I don't know the other one about who it's to, who it's from, the date, the subject that's available, regardless if you get metadata or not. And to, I think Anonymous's good point before, the daylight savings time, whether or not, I would not consider that to be security-related data, but the ones that I've mentioned before, the type of the type of email system that we're using, our addresses of our internal servers, how the security configured, and certain Microsoft-specific machine-readable codes, we would probably want to not release to increase the risk to the city.
And what about like the domain keys?
Domain keys and kind of what specifically would
the DKIM,
right? So those are the settings that we are setting for us as security settings. We have to look at that carefully, but my initial reaction is that we would not want to release the way that we specify the level of the domain key. That's the DKIM. Okay, I have to remember that particular acronym, but we would not want to specify DKIM or SPF settings that we have set. That's my initial reaction to your question right now.
Great, thank you.
Just one question. Could you speak to any security issues that you would know of if you had released, let's say, the field titles? I mean, there's some like date, colon, and then, okay, so then the
I
date.
do not know of any security issues for releasing the headers, the
stuff on like the left side of the colon, right?
The social security number, the text that says social security number, colon. I think several members have talked about these are all standard and specified in internet standards. We would expect to see them in every email.
Right.
They're publicly known. Everything that's after that's specific to the city, and what I mentioned, we can consider. And by the way, to the question about third-party experts, I run the program and R&D team. In my past, I have programmed and I have done security engineering, but I'm not a hacker. I have chosen to be the guardian instead of being the hacker. But we have consulted our partners who are hackers, and they have come and they have told us that, yes, there is an increased risk to certain fields to be used by criminals who are attacking us on a regular basis. Obviously, that doesn't apply to everything, and it doesn't mean that header. So I just want you to know that even from our perspective, we did have a consultation with our partners who do specifically that. They monitor hackers.
Right. So I guess, Ryan, it kind of gets back to where we started. Not hearing any particular concerns about at least the field titles, which are obviously redacted in this document. I don't think we can really even have a productive conversation on specific lines and let's say what's on the right hand of the colon. So, at a minimum, I think we need to see.
Okay. Thank you, Michael. Chris. All right, are we ready for rebuttals? Any other questions for any of the parties? Okay. Mr. Cote, you have 3 minutes for rebuttal.
So I'll be brief. Once again, reiterating the point that 6254.19 exempts from disclosure any information security record if on the facts of the particular case disclosure would reveal vulnerabilities or otherwise increase the potential for an attack on an information technology system of a public agency. So that's what we're talking about here, increasing the potential for an attack. And we just heard testimony from the city's chief information security officer that yes, there are fields in email headers that pose an increased security risk. That's exactly what we're talking about here. That is exactly why we have withheld properly that information in this particular request. To the issue of redaction, I'd point out that the law does not specifically require a line-by-line combing of metadata to redact it. That is impracticable, and it is not what's required under the law. In addition, as we point out in the Good Government Guide, sorry, I lost my spot here to make sure I'm citing it correctly. Says there is no evidence that either the Public Records Act or the Sunshine Ordinance was intended to require public entities to search and then review and possibly redact metadata in electronic records. Neither is there, and then it goes on to say, neither is there an apparent legislative intent to require government agencies to produce electronic records if it would endanger the integrity of the original records or proprietary software. So my point to you is simply these documents were reviewed by our IT professionals. It was determined that the information that was redacted was properly done so to prevent an increased security risk to the city. And that is why we took the steps that we did.
Thank you. Anonymous, you have 3 minutes.
Thank you very much. So I think what your chair and vice chair have been saying are right on throughout this time. I will actually, however, agree with the respondent in one small case. It is not the case that every email header, and I'm just telling you this to be honest, it's not the case that every email header is standardized and defined in the RFC. Some of them that start with X-MS and X-Forefront and X-Microsoft, for example, would allow you to know which version of Outlook or which version of Microsoft Exchange are being used. Frankly, I don't care if they redact that information. Now back to the case at hand. I agree that certain, potentially some portions of the headers may be considered information security records. But the Sunshine Ordinance goes beyond the CPRA. It says information that is exempt from disclosure shall be masked, deleted, or otherwise segregated in order that the non-exempt portion of a requested record may be released, etc. It doesn't say reasonably segregated. There's a reason that the Sunshine Ordinance goes beyond the CPRA. I would ask that you find all of the violations on page 539. It is the case that the supervisor of records issue is in a different case, but that's for 19047. In this case, they are in fact the respondent. I don't know why that's being ignored. That's 67.21D. I would ask that you order the disclosure of at least all of the email header names except those that start with X-MS, X-Microsoft, and X-Forefront. And I'm actually willing to negotiate for more of those names even being not released. But I'm not willing to negotiate over the email addresses, the timestamps, the date information, and all of that information for both emails that I requested. I ask that you find a violation. Thank you very much.
Thank you. Members? Now's the time to formulate a motion or have discussion to help formulate a motion.
I have a question. I realize in this instance, we're talking about a very small number of emails, but in the future, we could be talking about a very large number of emails. If the city thinks that all of these different categories need to be redacted, do they need to only redact the information to the right of the colon in every single email, or could they provide a list of these are the categories that we are redacting, black it all out, and know that you are not receiving this list of categories for every single email? No.
I don't. You
Not
can't.
acceptable.
That changes the actual record.
Mm-hmm.
You're now altering the public record and omitting.
So it has to be done for
It has
each
to be
one.
done that way. So either they redact it in the way they did, okay, or they redact everything to the right of the label of the field as per policy or guidance or directive or something. I mean, I think it would be interesting to note that if there was, what's the difference between this particular email and the information on it versus another one that, in that kind of way, and be able to show, for information, for email that a neutral party may say, you know what, the information that has been revealed publicly in this email, that shouldn't have been done. And show us why and how. And I think that's important for us to be able to make a informed decision. It shouldn't be just based on concept because somebody thinks or feels that it's a security breach or caution in that way. They have to show it in some way. We have had instances where certain information couldn't be shown because they were of some investigatory nature or they were of some human resources nature, and we don't have the ability to see things in camera. And those items we have referred to the Ethics Commission because they can. So, and then they can make a determination based upon with what the conclusions that we've come up with or determinations. So I think that's I think that's where we should be at. We should not take this lightly. I mean, we should have the evidence shown to us as to, you have security, we're being told that there are security professionals that have had their hands on these documents. And we're being told that they feel that these items are vulnerable. Well, we should hear from them. And just as a general case, there has to be, under the Sunshine Ordinance, a representative who has to have that information to be able to answer it so that we can come up with an appropriate determination. And we've adjudicated that before and found and have sent back continued cases and requested that the person who is actually the custodian or the person, and in this case here, these security professionals would also be custodians because they've touched the document, they've had it in their possession, and they were the last ones to have redacted it. So it would be absolutely be appropriate to ask them to come in and explain why they felt those particular headers were redacted to the left of the colon, or including the colon. And we can take any other email that has been produced with the visible headers and show it side by side and just say, okay, these are the same headers. Here's an email from this department. Here's the redacted email from this other from the same department. Show me which fields are the most cautious for you. And let them show us. I think that is absolutely appropriate, because another case like this is going to come. And it's going to come, and it's going to come. I mean, I'm surprised we haven't had Smith versus San Jose cases up the wazoo. That's a whole nother ball of wax to deal with. So, all right, is there a motion?
It seems I'll make a motion for a 6721D violation to find the documents public and call for the process outlined in 6721D to reassess what should properly be marked out.
For who to reassess?
For the city attorney's documents, right? Whose documents are they? It's the city attorney.
But the 6721D regards the supervisor records to determine whether the record is public or not. So is that what you're asking for?
Isn't that the process by which we determine a record public, and then, or is that a different?
No, it's a requester can go two roads. They can go to the supervisor records to determine whether the record requested is public. That's kind of the express lane, because you have one person, or the city attorney's office has already deemed these records on some list as being public or not. And if and should provide within 10 days that determination. And I think the petitioner has stated that they didn't receive I'm not sure, I have to go back, I'm not sure. Let me just ask, Anonymous, did you receive a response within 10 days from the supervisor records?
I received a response that we can't give you a determination within 10 days, and the determination, the word determination, that came August 26th, over 100 days after the petition.
So you didn't receive a determination within 10 days?
Correct, and I believe that's what I'm supposed to get, so yes or no.
Right. Okay, so as stated in the ordinance, the supervisor of record shall inform the petitioner as soon as possible and within 10 days of its determination whether the record requested or any part of the record requested is public. So the petitioner is stating that that did not happen.
I think earlier that was the subject of a separate complaint that was addressed earlier on, and that is not the subject of
That's-
today's.
Okay.
Just as a heads, I think that was mentioned earlier.
I
It's
think
a
the
separate
petition,
item.
I think the petitioner in his rebuttal suggested otherwise.
It's, if you look at the timeline and the facts of the case that the Anonymous has put together on page 531, it does talk about, it implicates this particular part of the Sunshine Ordinance on the supervisor of record determination. At 531, the top box, the top slide, particularly looking at
Which
you know,
date?
the numbers
Oh, here.
5 and numbers 10, number 10.
May 18th, 10-day deadline for supervisor record determination expires. Numerous follow-ups for months. And then number 10, August 26th, respondent as supervisor of records denies petition 110 days after filing.
This issue is specifically in a future case, which we've heard in complaints.
Yeah, just a question to Anonymous. When you say the supervisor of records denies the petition, what do you mean by that?
They gave me a letter that says your petition is denied for these reasons. As in, I took that to mean they have determined that everything I asked for is not a public part of a record.
Could I?
Yeah.
To Anonymous, is there anything about, and the city attorney's office can respond as well, is there anything, because I don't, if anything in the other complaint that pertains to the supervisor of records issue, is that under like different requests? Is this something that we could actually, if we did address to potentially, I don't know, Anonymous's satisfaction, would it be something that could lead to the withdrawal of the complaint, that such that we don't have to impose on Anonymous's time or the city attorney's time to rehash information that we've got in front of us now?
I'm trying to understand your question, sorry.
Sure, I'm just, my understanding from what I've heard is that there's another complaint pending pertaining specifically to the supervisor of records.
Yes, so there is a case called 19089 that was pushed up to the full task force by one of your committees last week, but that is specifically that the supervisor of records, who is the city attorney, didn't respond within 10 days to the case you just adjudicated, 19047. But in this case, it's the same respondent, right? They also didn't respond to the petition in this case. Does that make sense?
Yep.
Yeah.
There are at least 3 or 4 cases.
Right.
Relate to the metadata issue.
Vice Chair Wolf.
So all of these metadata cases conceivably are interwoven. In other words, how we make a decision on one could have ramifications for others potentially.
Yes.
We have a technology committee that hasn't met recently. This seems like well within the realm of technology, and it really, to me, feels like we should unpack this using whatever our best methodologies are before making any further orders of determination. And with that in mind, I'd like to make a motion for a continuance.
I'll second.
Okay, so there's a motion for, hold on, motion moved by Vice Chair Wolf, second by Member Martin.
Just want to make sure I'm not
Member
technically in trouble. I thought there was already a motion on the table, or do we have to dispel
That
it?
was made by,
Yeah, do you want to
I
withdraw
believe
that?
there was a motion made by Vice Chair Wolf.
But it
Sorry.
never got a second.
There was no second.
There was no
Okay,
second.
that's what I want
so-
to make sure of. Okay, that's all.
Yeah, okay. All right, so, and you want this also, so then you want this referred to the Technology Committee
I think that's the best place to handle this.
for the
unless-
purposes of,
Can we refer all of the
I
metadata
was going to.
cases
yeah.
to the technology committee first?
Yeah, I strongly believe that basically this whole thing needs to get taken apart, not necessarily through the same process as our complaint committee, but really mapping it out. I think that there probably are some experts in the San Francisco community that we could reach out to about inquiries for this stuff. They may even bring representatives. I don't know, but like, I don't feel like we currently have the right field of knowledge to take this on and continue moving forward.
Okay, Member Yankee.
I was only going to say, what we were talking a little bit earlier, I mean, it seems like there's just such a heavy amount of redaction that's here, though. I have concerns of how much productivity we'll be able to have even at a committee level to unpack this, because, like I said, we don't even have what the field titles are. I mean, I think, I think it'd be very productive to have that conversation once we know what the field titles are. Then we can talk about, well, is this a sensitive thing or is this not? But as of right now, everything was blacked out. So we can't even bring someone in and say, yeah, this, line 8 looks like it might be a security issue. Line 10, maybe not quite so much, because we don't even know what line 8 and line 10 are.
I mean, I think we could request from the city attorney to provide the left of the column stems, because we did hear testimony that they weren't concerned about the stems.
So, I mean, maybe we should wrap that into a finding of a violation of 6726, which is withholding kept to a minimum. Ask that they at least give us the field titles.
No, that's where I'm strongly pushing back, is rather than find a violation at this sort of initial level that we can identify, like, let's push this stuff into a field and really navigate it. That's where I come from. And I would request that the city attorney provide the left side of the stems for us to see what is in the category side.
Member Tyler.
The other side of the coin is this. Unlike the previous case where no redactions were made or even attempts were made, this is a little bit different. In at least they've tried to, place that line. Procedurally, we could do two things. We could continue as is, or, as Member Yankee suggested, find some basic violations that we're all in agreement with, do the order determination, and then refer this to the Technology Committee to sort it out, just like we would to EOTC. I'm in favor of that because we get something on the record. We set a precedent. We've already set a precedent. We've already ruled on the previous case. I'm afraid if we just continue this one into the Technology Subcommittee, that they're all going to go that direction. At least the complainant will get some action from us, some order determination, however small, and then we can really kind of get to the nitty-gritty of this at the next stage. So I would support a motion for 6726 if you were to make that.
That's what I would make.
I would caution not to do that, and I'll tell you why. Any company or government, any kind of structure that has to deal with these kinds of things, any security professional worth their salt would be creating security policies, especially when it comes to the security of certain information. For instance, under HIPAA, probably the most vulnerable of information is people's health records, okay? Highly redacted stuff that gets completely withheld, investigatory information and so forth. There are people spend a lot of time and a lot of money is spent on researching what is and what isn't security vulnerable. I mean, it's a whole business. It's a whole sector of the technology world. So I think that we have to respect that. And the city spends a lot of money on that, okay, in order to do it. We've passed laws on privacy. And then we have to hire all kinds of folks to determine what does privacy mean and create a balancing test between what is public or should be public and what should not be public. So I think it would be better, because what's going to happen if you go through, if this particular requester is going to bring how many cases? 10, 15?
Yeah.
Okay.
Maybe 10.
Right, 10 or 15. You know how many other good government watchdogs are out there? Could be asking for the same thing. We'd be bogged down for years, okay, if we don't come up with some sort of rubric that we can look at something and say, okay, on the checklist, yes or no. And it makes it a whole lot easier, and it makes it more familiar and comfortable for the city family to determine what can or cannot be redacted or withheld or what have you. if the city has a problem with those things, they can go to court and ask a court for what their determination is. But the court first is going to say, have you exercised the local process, which means us or the Ethics Commission? Okay? That's what they're going to ask for first before any court of law is going to make a determination. So I think in order, and I've asked this before on many other items, instead of trying to get into splintering up the issues for each and every individual item, let's get a rubric for what the item is. This can't be just a singular policy just for the city attorney's office. City attorney advises every office. So if somebody were to go to the Department of Public Works and ask for a department head or a supervisor's email, are they going to get the same advice from their deputy city attorney as far as redaction of headers? And if not, what does that mean for the security of the, what policies do we have here in the city? That is also our job, is to also report to the Board of Supervisors when we find that there are problems, either with the ordinance or in the way the ordinance is being implemented. And so I would rather go down in a more comprehensive view, and that way we can determine when there are specifics that seem questionable. It makes it a whole lot easier to focus on those issues instead of trying to, for an hour and a half, almost 2 hours, to try and figure out based upon very, very specifics. I would love to hear from the city attorney's IT professionals that redacted this email as to how they came to determine those fields were vulnerable. All of those fields that were redacted. Because just from my professional experience, I can't see how all of them would be.
So you're speaking in favor of the continuance then?
Yes, I am speaking in favor of continuance.
Just one quick point, Chair Wolf. I just want to make sure that we're not going down the slippery slope of transferring the onus of the redactions back to us. It sounds like we might be by trying to come up with this rubric, or is it just kind of opening up a dialogue with the city body family?
Right. I guess the charge, one of the charges that, or one of the areas that the IT committee can look at or should look at is there a citywide policy? What do other departments do? Let's collect and see, let's compare and see what it is. And, if, what's good for the goose, good for the gander kind of thing, and dependent upon the types of emails and whatnot, then you can start asking questions. It's like, here's another department head having somebody got an email between a department head and the mayor. No redaction. They got it. It's public. Well, why was that now allowed and not this other one? Well, who's looking at these things? Is anybody looking at it? Or is there some issues? And I think that's important for us to tell the city that if there is some precaution that needs to be made, and if there is a policy or lack of a policy, there should be one, that's what our job is here, is to be able to also have that level of review.
Just for a little clarity, my understanding based on when the motion for continuance was made is that we would start with the rebuttals when this came back. Is that correct?
No, we would start after the rebuttals.
But the continuance was made before rebuttals.
No, it wasn't. We just had rebuttals.
Actually, technically,
we had rebuttals?
It hasn't been made yet because it hasn't been seconded.
No, it has been.
It has been seconded. Member Yankee. I'm sorry, Member Martin seconded it.
But did we get rebuttals?
Yes.
Okay,
we had rebuttals.
Okay.
I think that that's the way we should go with that, and then we can determine when the committee meets what the course of action to be able to come up with an answer. Now, the next part of that is taking the compendium from this particular petitioner. Do we review all the issues regarding the redactions.
I'm pretty sure rebuttals haven't happened.
Yes, they have. We provided 3-minute rebuttals.
Yes.
They happen.
Looking for a motion, that's why we're at that point.
Okay.
Yeah, I wouldn't ask for a motion unless rebuttals were made. So so then the question is Member LaHood suggested, should the compendium of this particular petitioner be sent to the IT committee? We have two issues. We have the metadata issue and we have the redaction issue in the metadata. Okay. Yes?
Yes.
Okay. So I will so order that as my prerogative as chair. Okay. So is there any other debate or discussion around the continuance?
May we call that a referral to the EOTC instead? Since you're actually not continuing it, you're referring it to a committee.
We're
But it's the
continuing
technology.
the case.
You can only do one or the other. If you continue it, it remains at the task force. If you refer it, it goes to the committee.
Okay.
Refer it to the technology committee.
Well, we can continue and refer. I mean, the case is still open.
We can't do both.
No, but the case remains open.
We cannot do both. We can do one or the other.
Wait, but once it's continued, isn't it up to the chair's discretion where it goes?
No, not necessarily.
No.
That's
Continue
only
remains
after
in the same body.
determination is
Only
made.
after a determination.
Yeah, usually that's our general practice. I don't understand. So we want to refer it back to committee. Okay.
Or
So-
refer it to a new committee.
Okay.
Right. I will update my motion to say referred to the technology committee.
Yeah, and then then it's got to come back to the task force.
Right.
So
Yeah.
that,
Yeah, and we
because all these
provide-
cases are still open.
Right.
Okay. So
It
that.
will come back to the task force.
Okay, that means, though, that for all the cases that have been or will be agendized for this petitioner, they will all be put on hold.
Would
Until-
you like to put those before EOTC also?
It's the
I
IT
mean,
technology.
before technology committee?
Well, that seems to be everybody's nodding their head, so I just want to notice that.
The soonest we could schedule a technology.
Well,
We can-
that's
we can have that discussion.
availability for those
What about the
members.
case we have ruled on prior to this?
I don't think that necessarily, we could send that forward too for review, but I think based upon if I'm guessing right, some of the other cases are similar to the first case. Similar, okay. So, we could deal with that when the time comes with regards to any reconsideration.
So I'll second the motion of the referral to the Information and Technology Committee.
Okay, and I will just add to that once the Technology Committee has finalized their findings, that all these items will then be ready to be agendized. Okay? And I think there should be a recommendation also as to whether they should be combined or not by that committee.
We're against various departments, so I don't believe combining them would be,
Okay, but some of the departments are the same.
but maybe a recommendation from the committee regarding this whole issue
Yeah.
should come out.
Right. Okay.
And maybe a draft letter to all city departments
Okay.
or something to that effect.
Okay, so we're changing the motion from being continued to referring it for procedural purposes, to referring it to the IT Technology Committee for review of both redactions and metadata disclosure with, and recommendations to be forthwith. All of these files will be on hold for review by that committee and then be re-agendized for the task force at a future date.
All the files except for the one we voted on, which we're not, is still
Right,
moving through. Yeah.
that can be part of
Right,
considering
but if he
everything
wants
else.
to do something, that's closed for the time being.
That's right, that
Yeah.
one's, it's done, yeah, there's
Right.
an order for that one.
Or if they.
Okay? Okay, are we clear?
Yes.
Everybody clear? Clear?
Yes.
Clear? Okay, clear? Okay. Any
just-
public comment? I'm looking at everybody in the room. Yeah,
So for the previous case for 19047, I think some of the metadata issues that related to the ICS formats and the calendar, et cetera, I don't believe those exist in the other files that you're referring. So to that extent, if the task force wishes to sort of revisit that at the technology committee, I would suggest that as well.
Okay. We'll do that. All right, we're ready for a vote?
Just to clarify,
No public comment.
the matter will be referred to the technology committee. And Anonymous, are you still present?
I am. I don't know which exact files are being referred. So
Yes,
yeah.
I will contact you in the next few days. But you did receive notice of hearings for your other complaints. However, those will no longer be going forward. I'll send you notice that they have been moved and the scheduled hearing dates will be rescheduled for the technology committee.
Okay, they are not all metadata complaints, just to be clear about that.
We can discuss that.
Okay.
If you don't mind, we can talk tomorrow and we can figure that out.
Certainly.
Okay.
On that motion,
Public
Vice
comment.
Chair Josh Wolf,
I
Aye.
asked for public comment already. Go ahead.
Member Martin,
Aye.
Martin, aye. Member Yankee,
Aye.
Yankee, aye. Tesfa absent, Kanata absent. Member LaHood,
Aye.
LaHood, aye. Member Kate,
Aye.
Kate, aye. Hinsey absent. Member Highland,
Aye.
Highland, aye. Chair Wolf,
Aye.
Wolf, aye. The motion passes. The matter is referred to committee.
Thank you. Thank you all for your indulgence and patience. Appreciate it.
Thank you.
Chair Wolf, I believe that Anonymous would like to speak on item 10, if you'd like to take that item out of order.
Item 10.
It is review to consider amendments regarding complaint procedures.
Complaint committee, okay.
He did indicate he wanted to speak on that, and if you want to take it out of
Okay.
order to,
We can do that while he's still on the phone. Is there any objection to taking it out of order? Okay.
Are we hearing from him when there's a motion, or are we changing our procedures
I
to hear
believe he
from
wants
him?
to speak during public comment on that item, and just so he doesn't have to
you.
stay on the phone, I suggested taking it out of order.
Taking the item out of order, but also taking public comment out of order from the item itself, too, is what you're saying?
No, the public comment follows the item, so at that point, he would talk.
Yeah,
Once
so we
there's a
want to
motion.
take up the item now.
Once there's a
so-
motion.
Right,
Great.
once there's a motion.
Sounds good.
Item number 10, review to consider amendments to the SOTF complaint procedures.
I'm looking at this, and I don't see the,
If I may.
yeah,
It's under C4,
see, oh, there it is. Okay, got it. Thank
and this
you.
is the language that we discussed
Right.
at the last Rules Committee.
Right. Okay, so this was discussed at the Rules Committee?
Rules Committee,
Rules
yes.
Committee, to amend C4 in our complaint procedure to add at the bottom of the paragraph, members, and it continues in the same paragraph, members of the public who attend meetings of the Sunshine Ordinance Task Force are expected to behave responsibly and respectfully. Persons who engage in threatening and/or menacing behavior may be asked to leave. Any member of the task force may call for decorum due to disorderly conduct of meeting participants. This provision supplements the rules and policies adopted by City Hall, the Sheriff's Office, or the Board of Supervisors related to decorum, prohibited conduct or activities, noise, etc., and is not meant to be exhaustive. Okay, discussion.
Just typo,
Yeah.
Sheriff's Office and the Board of Supervisors, I would think. I think, or,
No, that's supervisors is spelled correctly.
no,
He's saying it should be an and instead of an or.
I believe so.
Here's the supplements the rules.
Yeah, it's an and.
Oh, okay.
So which, this is in front of the Rules Committee? Did you guys have a lot of people show up for the?
We did.
Yeah. And
Yeah.
was everyone okay with this?
Yeah, this
Language at the end.
This was based on the letter we got from the.
Okay,
Yeah.
all right.
Yeah, in fact, the custodians that wrote, some of the custodians that wrote the letter, they were pleased with the
Okay.
results of this.
Okay.
May I ask, is this something that you wanted to add to the back of our agendas?
Yeah, and it will be also a preamble to every meeting and every committee meeting.
Template.
And I would suggest that the chair recite it. The chairs of each committee, and including the chair of the task force,
Okay.
recite it at the beginning of the meeting, after the meeting's been called to order.
Can someone define what behave responsibly and respectfully means exactly?
We had that discussion.
Right, and I think that's left up to,
Call the chair.
and it states in the next sentence, any member of the task force may call for decorum. So I think it's really meant to be a little open-ended.
Okay.
We specifically wrote the part about being asked to leave a meeting as being much more safety-oriented, though, if you notice that particular sentence focuses in on the threatening, menacing behavior.
Yeah,
We were
mean-
asking people as a general courtesy to be respectful and responsible, but the part about the leaving of the meeting
Yeah,
is
I
much more
mean-
narrowly tailored.
That first sentence I find to be a little bit, I don't know, it doesn't sit well with me. The rest of it I'm fine with. The first sentence to me feels like the, whatever were they the heads of departments or?
We looked at several different templates.
Maybe you
Went
can
from
say
very.
attendees instead of members of the public?
No, it's the behave responsibly and respectfully without any like definition of either of those words. It feels like a bunch of
Well, do you have a suggestion for something?
scratch that entire first sentence and just persons who engage in threatening and or menacing behavior may be asked to leave. Any member of the task, just scratch the first sentence. It doesn't feel necessary, and it feels like it's added there to complete the format.
We could just have members of the public who attend the meetings of the SOTF and engage in threatening or menacing behavior may be asked to leave.
Well, yeah, I mean, we could remove the are expected to behave responsibly and
Right.
respectfully, and then go to remove
thing.
persons, and then go straight to who engage. Yeah.
Yeah.
I mean, we tried not to define what decorum is, per se. I mean, because otherwise you could say are expected to follow the decorum of the room. The question becomes is kind of like when you walk into a courtroom, there's a certain amount of respect and decorum when you walk into that hearing room. So the question then becomes, with regards to behave responsibly and respectively, how do you fit that in?
See, I don't really think that we should be asking people to behave responsibly and respectfully. I think we should be telling them that they can't engage in threatening or menacing behavior.
Just so you know, the background, Vice Chair Wolf, we had some templates that other bodies use that were much more detail-oriented about name calling, applause, carrying signs, and then the other side of the coin is, since we're kind of like a court of last resort, and we should preserve as much as possible freedom of speech, not to go down that road. So we went for this generalized decorum line, and especially, focus on the threatening and menacing behavior as our watermark, if you like. That's the history of it.
Yeah, I mean, I remember when the thing happened and walked through the pieces, and I felt like we were being bullied into adapting decorum standards, and I found that whole thing a little bit ironic.
Well, I think other members did too. I think we are trying to come up with something somewhat, something that could be said or something in writing. And it seemed that this, by everybody involved, felt that this was applicable. I think the question is for those custodians that refuse to come to a task force meeting because they because they felt otherwise than to the other party, then, you know, how, the question is how do you then deal with that in a way that we are also respecting, demanding some respect to the room?
Actually, Chair Wolf, the last sentence kind of covers that on the back end, related to decorum, prohibited conduct, activities, noise, etc. Not meant to be exhaustive. So that.
Well,
if-
then
so we-
let's have a motion.
I have a thought, and I'm fine with the way things are now, but if the idea of expected to behave sounds, could we say are asked to participate?
I want a
The hearing
definition of
process?
responsibly and respectfully in order to include them in our legal language. It's a bunch of like weird language that's completely open to interpretation.
Yeah, we decided not to go down that slippery slope for exactly these reasons. If there's, you know, if there's better language, we can put that in there.
I mean, I still think the better language is to just strike that clause, and either we can keep this definition or keep it persons. But yeah, that's the part that I object to.
Ultimately, some of the other points were that a lot of this would be left up to the chair to be able to control the room and facilitate the meeting. And so you could add to the end of that sentence, behave responsibly and respectively, you know, as determined by the chair.
I mean, it's already clearly up to the chair. I mean, I'm going to vote the way I vote. If someone wants to make the motion with the way it's written, that's fine. Like, I'm not really invested.
Well, we're
in
having a
this.
discussion about it. Oh, if you're not invested
I mean,
in
I'm
it,
invested. I've shared what I think. I know that I do not like the whole expected to behave responsibly, and respectfully. I think that responsibly is entirely open to interpretation on any axis, and respectfully is questionable when you have people from the city that have disrespected people's requests for information to then tell them you have to be respectful to these people that you feel have wronged you, and it just feels it doesn't sit well with me.
Well, I think it's more about respect for us and the room at the same time, so that we can conduct our meeting without a lot of disruption, because somebody is
Right,
not
and
keeping to the point.
And hopefully everyone recognizes that no matter what's written here, it's not actually going to have that much of an impact on the way people behave.
That's fine. I mean, you could say instead of expected, you could say, you know,
Asked to participate in
or
the hearing
self-facilitate,
process.
self-facilitate in a
Respectfully.
responsible and respective manner. Then
I
it's
mean-
not up to us; it's up to them.
No, but I
and how
still
they
think
see this.
that the prohibition of threatening and menacing behavior is fully sufficient.
But we're talking about something less than threatening. Also, Go
I
ahead,
think the
Member
way
Martin.
it's written does more good than harm. I don't see any harm in reminding people whatever is in their head, what they think is responsible or what they think is respectful. This is a serious thing that's happening that they're a part of, and it's to both the respondents and the complainants. I think it's just a reminder.
Yeah, I mean, we could start a little softer and say,
It's-
are asked to behave responsibly and respectfully.
Well, I'll make a motion to approve it as it is.
Moved by Member
Thank you
Martin.
for doing that.
Welcome.
Is there a second?
To approve it as it is?
Yeah, they spent time on it. They
Yeah.
had the people come before them, and they wrote it.
I'll
So-
second that.
Moved by Member Martin, second by Member Highlands. Is there any other discussion? Seeing none, any public comment? There's no public.
No, there is
Oh, wait,
public
there is.
comment.
This is
There
here.
is
Huh?
anonymous.
Oh, anonymous, I'm sorry.
Hello?
Yes.
Public
Yes.
comment. Go
Let me
ahead.
know when my time starts. So,
You can begin speaking.
hello?
You have 3 minutes.
Okay. So in preparation for my cases today, I actually reviewed many of your past hearings and the Rules Committee. I've never physically been to your meetings. First, the concerns about physical safety, intimidation, and menacing behavior are absolutely critical, and I hope that if necessary, you, like a court, have a sheriff or a police deputy or somebody else like that at your case, and everybody understands these are important legal matters. However, unlike most city meetings, these hearings are the public versus the government. And the right of the public to petition the government for grievances is paramount to a democracy and should outweigh the concerns of the government, specifically in the narrow issue of name-calling and kindness that were mentioned during the Rules Committee. Sadly, it is possible that one party will need to accuse another party of either lying, acting in violation of the law, or acting incompetently. These are very unkind things to say. You may not consider them respectful, but sometimes they're part of a case that has to be made. Now, I empathize with the individual custodians. No one likes irate customers when they're in customer service. But I, as a complainant, have numerous privileges that others may not. I have time to do legal research, write very formal letters, and consult with attorneys if I need to. And I audit records because it's something I like doing and I believe it's the right thing to do. And my life won't be ruined by a failure to produce most records. But some people's lives may be. I don't think in your responsibility to determine whether records are public or not, anyone's behavior should be considered. Therefore, I urge you in your amended rules, first to prohibit all illegal acts, like anything violent, intimidating, or menacing, but not to create any restrictions on speech or expression beyond those already mandated by the law, including guidelines that may have a chilling effect. And finally, I'd ask that you include any words, say any person, because it's just as possible that a city employee would act this way. Now, one of your custodians commented that San Francisco should not go as the way national politics is going, and she was right for a different reason. This should be an example for democracy, and the hallmarks of that are freedom of speech, freedom of the press, and government transparency. Thank you for your consideration.
Yeah, DCA Peterson. Doherty.
Microphone. I don't think there's any problem with the language as it's written, but there could be a problem with the language as it's implemented with respect to First Amendment concerns. That's all.
With regards to which part?
The first sentence?
The first sentence?
Yeah.
Okay.
Freedom of speech.
Okay.
I mean, menacing, that's not a problem, but disrespectful could be a problem.
I actually think menacing is also a problem, personally, and to some degree threatening, for that matter. Those are a little bit further on the bad. I share some of Vice Chair Wolf's issues with the way why we're here. Ultimately, not because of the hard work of the members of the task force who've worked on this. I think this is almost impossible to put down in a policy. I also think it's ultimately largely meaningless, and instead it's mostly a response to some people who come to these meetings with some regularity, and I can understand those concerns, but I just have, I hesitate because I can count and I know what might happen, but I don't like having to vote on things that won't really matter in ways that, notwithstanding anyone's efforts, these are hard things to define, and I don't think you really can. And I have problems with it as well, just because of the way it's difficult to define these things. The fact that I don't think anybody on the task force believed we had any issues controlling decorum, for lack of a better word. And in my time here, I haven't seen anything particularly disturbing, but I know that there have been maybe issues in the past. I think it's a good attempt to try to address a problem that's intractable, hard to solve, and not least because of the problem with the first sentence, I would be inclined to vote against this language as presented.
So I brought up 6715 D at the Rules Committee when we were discussing this. And I'll just read it into the record because to me that this is kind of the crux of where we are. It states, policy bodies shall not abridge or prohibit public criticism of the policy, procedures, programs, or services of the city or any other aspect of its proposals or activities, or of the acts or omissions of the body on the basis that the performance of one or more public employees is implicated on or on any basis other than reasonable time constraints adopted in the regulations pursuant to subdivision C of this section. So it's, to me, that kind of says that there's kind of open season for anybody to comment on the performance of the people that provide services to the people. So, you know, I think I hear what folks are saying. I'll, you know, I think it's important to have something in writing. I'll support whatever the body wants to move forward at this point. But this is the starting point. However we end up, you know, I think there should be something. The last line says this provision supplements the rules. So if you state that this provision supplements the rules that have been adopted by these 3 other entities, and that means we also accept all the provisions of those other entities too. So
Wait, can we map out what all those provisions of those other entities are? 'Cause you just
we did that
we did that in the Rules Committee.
Okay.
Those are the things we were looking at, and we boiled it down to this.
Right, but then you added all of their things on top of that.
No, those are our things.
No, the way this is written is the provision supplements. Okay, this provision is in addition to the other ones that already currently exists. But what we're saying when we do this, it's really more about us saying that this should be attached to those other ones. It doesn't say that we are adopting the other ones. If there needs to be some more wordsmithing on that, then I would say do that. And I'm just looking at our legal counsel to see if my logic is correct on this or not. So this provision supplements the rules and policies adopted by City Hall, the Sheriff's Office, and the Board of Supervisors related to decorum, prohibited conduct or activities, noise, etc., and is not meant to be exhaustive.
Well, the way I would read that is that, in fact, you know, you already have adopted all of those policies, and that, you know, anything else you do is on top of that.
Right.
So, yeah.
And in fact, we don't enforce all of those policies
No,
and don't plan to.
We haven't adopted them.
Yeah.
We have not formally adopted them at all. In fact, the whole purpose of this exercise was to create a set of principles with regards to this. The other way that I think you could also interpret that last sentence is that we're creating a provision that needs to be added to those. I don't think we have the authority to add that provision to those existing policies.
Well, just for us, we can.
Right.
I have a question.
Yeah.
Is everybody okay with the one sentence, any member of the task force may call for decorum due to disorderly conduct of meeting participants? Are we okay with that sentence?
Yes.
Yeah.
What if we were to add that sentence, sit with it, and then rethink the others or add more as needed, or do you feel like this needs to all happen at once?
Well, I think the one above it also is applicable.
Yeah, maybe we just stick with the 2 middle sentences for now. I think those are the ones that most people are have at least some level of comfort with, and we drop the first and we drop the last sentence.
Yeah, and I think lead with any member, and then the second one would be persons who engage.
Yes. Yeah.
In that order.
Right.
Well, but not just members of the public, like any participant.
No, any member of the task force may call for decorum
Oh,
due to
got it,
disorderly
got it,
conduct
got it.
of meeting
Yes.
participants.
Yes.
Next sentence.
Persons who engage in threatening and/or menacing behavior may be asked to leave.
And maybe it's just
Period.
threatening and not menacing because menacing was an issue. No, I don't know.
It's, you know, this only comes into question if it becomes an issue down the road. If we are debating menacing, something happened.
Right.
Right?
Yeah.
Okay, so you can have this conversation all evening, but what the words mean aren't going to be decided really until something happens.
Right.
And this is really just to put people on notice.
Yeah.
You know, please be respectful in this hearing. Okay, that's in whatever people have in their mind of what is respectful or what's good behavior or whatever else, then they'll display that. But again, it's just a preamble to starting a meeting saying this is a serious meeting. Please treat it that way.
Yeah, and those 2 sentences are easier for the chair to read and get right into the meeting.
So I guess I would, since there was a motion, I'd move to amend the
Okay.
motion that was there, with the edits that we made, which is any of the member of the task force may call for decorum due to disorderly conduct of meeting participants, persons who engage in threatening and or menacing behavior may be asked to leave. Just that.
Second.
So
You
that,
the original
that brings
Yeah,
up a light bulb for me about something. I think it's worth stating that as part of respect for our process, that the hearing process be respected, that we are allowed, that we, be given the opportunity and for everybody else involved to complete the process and the procedure. And I think that may be something worth stating, is that here's the procedure, to be respectful of the procedure and allow it to get through the end.
I mean, I agree, but I think it probably could be lumped under that disorderly conduct, if you're,
Okay.
rubric.
Those two sentences that Matthew put forward will get a yes vote from me and probably almost nothing else.
So I think
We're all doing this for you,
at
Vice
least
Chair
those two
Wolf.
sentences
I'm
will
not
give us a
saying
unanimous
that.
All
vote.
I'm
about
just like-
you.
He's like,
No, but I
But I
think
think
also
Kate's are kind of on the same page.
I'm fine. I mean, menacing is a synonym of threatening. So, I will vote for that.
I think
Those
also
two-
to
those two
remember that
sentences in that
the chair of whatever committee meeting or can say whatever they want, essentially, before the meeting starts.
It's true.
I mean, if
They
a
control the room.
right, if a particular chair wants to say, this is please respect us, then great. That's
Have that prerogative.
Member Yankee have something to add?
Nope,
Oh, okay.
I'm done.
May I
think
ask
you
you
were-
to state it again slowly so
Sure.
I can?
Yes, so it's going to be the sentence that starts with, any member of the task force may call for decorum due to disorderly conduct of meeting participants, period. Persons who engage in threatening and or menacing behavior may be asked to leave,
Period.
period. That's it.
and I'll withdraw my prior motion.
You don't have to.
Okay, good.
We're amending it.
Amending it.
So, Member Yankee moved to amend. Is there a second?
Second.
Okay.
So, second by Member Highland. Okay. So let's go for the amendment. Can you please call the roll on the amendment?
No public comment.
Oh, public comment, as no public in the public area to comment.
Public domain.
Please call the roll for the amendment.
On that motion, Member Martin.
Aye.
Martin, aye. Member Highland.
Aye.
Highland, aye. Member Yankee.
Aye.
Yankee, aye. Vice Chair Wolf.
I'm.
Wolf, aye. Tesfa absent. Kanata absent. Member LaHood.
Aye.
LaHood, aye. Member Kate. Kate, aye. Hinsey absent. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, so now, because we did it by amendment, now we're back to the amended version. Please, is there any public comment on now the original motion that's now been amended
To adopt the language.
to adopt the language? Yeah, go ahead.
Am I allowed to speak for
Yes.
this motion? Okay. I completely support it. This is exactly what your task force should do. Thank you.
Is there any other public comment? And I'm sorry for Anonymous for not, for stating that the room was empty, because the room wasn't empty. Okay, any other discussion? Seeing none, please call the roll.
May we take this
By acclamation?
acclamation?
I guess we can. Okay. Are you okay with that? Sure. Okay, made a face. Okay. Seeing no objections? Motion is approved. Okay. Let's get through the rest of it.
Next item is item number 9, file number 19099. Here to consider action to close Sunshine Ordinance Task Force complaints due to inactivity and other violations of the SOTF complaint procedures for the following files listed on the agenda.
Okay.
Just to provide a
ahead.
summary, it's very similar to Mr. Bruno's case. They were submitted. They were either continued at one point or no parties showed up for the scheduled hearings. We did send out a letter, follow-up letter, asking them to pick a day to show up for a meeting, or we were going to close their file. We received no response. Therefore, it is on the agenda for your consideration.
I'd like to make a motion to close all of these listed complaints due to inactivity.
I'll second.
Did
Member
Mr.
Kate?
Zuckerberg not get back to us?
He's a little
This
busy.
guy's busy. He's got
I don't think
other
it was
things on his mind.
I don't think it
think.
actually was
Okay.
spelled that way originally, to tell you the truth.
Okay. All right.
Um,
Well, I'm satisfied.
I do have a question for you all, is that considering the names of these folks, and considering the last bunch that we also closed, is there any concern or issue with receiving complaints in the future?
I think we should allow Liz Arbus, Mark Zuckerberg, Lucinda Page, and Ashley Rhodes to come forward as their real human beings and make these complaints if they want.
And Carlos Petrie.
Yeah, him too.
I see no issue with.
You see,
No issue. And
issue.
if there is, we'll hear about it and we'll deal with it then.
Okay.
And we can, once if we suspect any issues, we can take extra precautions. And like in this case, during the last stages, I would write a letter asking them to tell me what day they are available to show up, and they don't respond to it. I just would not schedule it because it would be a waste of time to schedule it if they never respond to me.
Right. And there is provisions for the administrator to close a file.
We would bring it to you in this format. If we
Okay.
notice something and we can't get a hold of the person and we want to close it, we'll bring it forward to the task force in this format to let you make that final decision.
Okay. Very good. Okay, any public comment on this item? If not, seeing none, no more debate, please, do we need to call, it's called, yeah, it's substantive, whereas we're closing it, so call the roll, please.
On that motion, Member LaHood.
Aye.
LaHood, aye. Member Martin.
Aye.
Martin, aye. Member Yankee.
Aye.
Yankee, aye. Vice Chair Wolf.
Aye.
Wolf, aye. Tesfa absent. Kanata absent. Member Kate.
Aye.
Kate, aye. Hinsey absent. Member Highland.
Aye.
Highland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes. Next on the agenda is item number 11, reports from the Sunshine Ordinance Task Force committees.
Okay, complaint committee, anything?
Yeah, we had
report?
a meeting, I think, last week, 2 weeks ago.
September 17th.
Yeah, September 17th. Yeah, there was one that withdrew. There was one that was closed. It was fine. There's probably 4 or 5.
Okay. And the minutes, I've now requested that the administrator include the minutes for all the committees, so that you can read them before the meeting. Complaints and amendments?
We had a good meeting. The zoo issue came up, and it's coming back to the task force with a recommendation that we forward it to Ethics Commission for noncompliance. We found that the library did comply with. This was the issue with Ray Hartz, and we said that they complied with our order. So that has been closed. And finally, we are referring a matter to the full task force in a complaint by a group. Oh my gosh, I can't even see how long this is. Against the police department for violating the Sunshine Ordinance Task Force. So that will be coming back to us. And we did we talked about a couple of other things, but one thing we talked about was this issue of nonprofits and city agencies and the way they work together. And Member Highland, we made a recommendation that I don't see reflected here, that a file be opened on this so we could have a broader discussion because this keeps coming up.
The 12L issue?
Yes.
Yeah.
If you'd like a file open, please just send me the language and we will open a hearing file.
Okay. Is there a way to know if Cheryl already has done that?
Probably not.
She has asked us for an opinion on this.
Okay, so it's in motion. Okay.
Yes, but if you could just send us the SOTF email address, please open a file with the following title, we'll actually open a physical file
Okay,
and assign it to the committee, and
okay,
that way we have a place to put all the documents for it.
okay. Thank you.
I know.
Okay, EOT? Anything? Did EOT meet?
EOT hasn't
Hasn't
been
met?
meeting recently.
Okay. Rules Committee, Fiona's not here, but what else did?
I'll talk to it, I suppose.
Sure.
Well, we already talked about the complaint
Lang.
procedure we just voted on. We also talked about parliamentary procedures for orders of termination. I see that's on this agenda, so that'll come up next. And then the other main issue we talked about was perhaps crafting some type of, or considering some type of resolution, encouraging all policy bodies to keep meeting minutes, and maybe send something out, expressing our, feeling that that's, a good practice. So I'm not sure if that's something we want to consider perhaps on the, for the full task force on a future one, or maybe that's an EOTC issue to draft some language. I don't know.
Yeah, so the reason why I brought this up is because at a previous meeting, I think it was one of the Clark brothers and at some subcommittee, and they basically pointed out that even the Sunshine Task Force is not required to keep minutes in the way the ordinance states, because it's basically only for boards and commissions enumerated in the charter. We're not enumerated in the charter. So, so even though we do it by precedent, because we are trying to do every single thing that the ordinance says a body should do, but that is something also that we would want to recommend for in amending the ordinance sometime in the future, that it would include whether enumerated in the charter and elsewhere, or something like that. It could be something as simple as that, or all deliberative bodies, or something or the other.
Yeah, we thought about in the meantime, though, at least express our
Right.
sense that it would be a best practice.
Right, but I think the thing was to have the task force agree to send out a memo to the city family stating that despite what the Sunshine Ordinance says, we urge all deliberative bodies to record the minutes and record the public testimony in accordance with the ordinance, so on and so on and so on.
Is that something we can get into the good government guide?
If they're willing to make us part of the review of that document, which there's a requirement in the ordinance for them to, for the city attorney to consult with us with regards to such items. So if they're interested in our input, then I think we'll have that conversation when we cross that road. So I think it'd be worthwhile to at least I think was there a recommendation from the Rules Committee to?
Yeah, I didn't see it actually reflected in the meeting minutes, but I believe that's what we decided, is to send it up to the task force for consideration of some type of
All right.
memorandum or resolution.
All right, so I think it's worthwhile to, as far as sentiment, as a resolution, we should actually take an action on that. So is there a motion?
Sure. I would move then that we, in accordance of what we talked about in the Rules Committee, move to draft a memo to all deliberative bodies encouraging them to keep meeting minutes.
According to the ordinance, or just in general?
In accordance with, which section is the meeting minute portion?
It's
6716. Yeah, in accordance with 6716.
Yeah, and it should be an urging. We
Right.
urge them.
And yeah, encourage for, urge
Encourage.
them for as best practice.
Okay.
I'll second.
So moved by Member Yankee, second by Member Martin. Is there any public comment? Anybody on the phone or in the room? Seeing no public comment, are we ready for a vote? It's a resolution, it's not substantive. Can we take it by acclamation? Seeing no objection, everybody's nodding their head for no objection. Okay. Item is approved. Okay, next item.
Item 12, Sunshine Orange Task Force Chair's Report.
I'm going to keep it short. There's not much that I have to report on. Most of the items that I was interested, we've came through the committees, and I attended those committees, and we effectuated everything that I was interested here. I've got no other correspondence or requests. Sure the administrator will mention that we did receive an IDR, which is being completed, and I'll wait for the staff report to reflect that. Any other discussion? Anything you would need to ask me or anything like that? Okay. All right, let's call the next item. Oh, any public comment? Seeing no public comment, let's move to the next item.
Item 13, Review of Parliamentary Procedures Regarding Motions for Orders of Determination.
Okay, so we've been going back and forth and having some indecision on what to do when we want to find no violation. And it's been confusing for the public, and there are varying folks that have been on this task force that I've consulted with, and general parliamentarians that I've asked with regards to how go about it. And I think the conclusion that I've come to on this is that the question that is before us, that a complainant or petitioner brings, that is the question before us. Is there a violation? And that is always the question that's before us. We just have to fill in the blanks as to what the violation is. And if we vote it down, then the question is, does that mean there's no violation? Okay? The problem is when nobody makes a motion. What does that mean? And to some folks I've spoken to, they say, well, then that means that the file is closed. But what does that mean, that the file is closed? Does that mean that there's no violation? Or it's like an abstention. There's not enough information to determine whether there is or is not. But does that actually mean that there was no violation? There could be a violation, we're just not sure, or something like that. So this was a kind of a discussion to try to figure out how should that work. And so I did draft just a short line to be part of our kind of procedures to see if how that works. So I'll open it up. Yeah.
So I read the way this is written, and I like the idea of clarifying this, but I don't think we can say it means there is no violation. I think it means there is no violation has been found. Specifically because we've had votes where the vote was like 6-2 for a violation, but because we were low on bodies, we didn't find a violation because one or two people said there wasn't a violation. And so sending the message that there is no violation when there was a vote 6 for a violation doesn't really make sense. So I think changing that to both means no violation has been found and case is dismissed.
Does that mean the same, though? No violation and no violation has been found?
No.
Explain the difference.
Because we have not been able to identify that there is a violation. It doesn't mean there wasn't a violation.
Or no violation determined.
Sure, we could go with no violation has been determined, but to say that no violation means that if there's a 6 6-1 vote for a violation or a 6-2 vote for a violation, that they walk out saying there was no violation, that doesn't make sense.
So I guess I have a problem with the word violation. I would say, because what do we do in the end? It's a determination. So why don't we just say both means that there is no determination? Because the determination is either to find a violation or not to find a violation. But it's our ruling, basically.
That works. I think no determination. There's been no determination.
Right, no determination. And that's essentially what we're trying to get at here, okay? The question is if an order of determination motion fails, okay, the question is does that mean that there's no violation? It's kind of like in court, if a judge says, I don't agree with the plaintiff, I find no violation on the defendant, the case is dismissed. There's a definitive decision that there's no violation versus I can't make up my mind whether there is or isn't one.
Chair Wolf?
Yeah.
If you look at the way our complaints are structured, it starts with the premise for allegedly violating and then lists the code section 6121, 6125. If, as a body, we don't find violations of that and no motion is found to find a violation, or we don't find other violations that came up as a process of discovery, and no one makes a motion for that, case is closed. If we started with nothing, then that's something else. But we're starting on the premise that the complainant filed this, and we're looking for against DBI for allegedly violating administrative, et cetera, goes on. Because we're starting from that point, I think we're okay with.
But I think it should be either a thumbs up or a thumbs down. I mean, I guess my concern here is that the public is coming for a particular decision. For us not to make a motion is really kind of a disservice to the public and to the city and to all the parties.
I think it's incumbent on the chair to explain to the public, none of the members have found this rises to a violation, therefore you're not seeing a motion, and this case will be dismissed. And that we can explain that, and the chair can explain that to the complainant, because they may not be aware of the mechanics of what we're doing.
Okay. DCA Thoreen.
If I may, just briefly, to touch on Josh Wolf's point, there seems to be a middle ground here. There is at least one case that I've dealt with where there wasn't sufficient people in the room to pass a motion. And so, because of the bylaws, it didn't pass. But it wasn't clear that it was not, denied. So, it seems like there are three things here. One is you can find a violation. One is you can clearly not find a violation based on the majority of the task force. And then there's this third limbo area where you don't know exactly because of the requirements. You have a requirement to have 50%, right, of the board, if I recall correctly, vote in favor of something. And if you have, I think your example, whatever it is, 5-2, you just don't have enough numbers to count. It just doesn't make any sense. It's not really a determination one way or another.
Right.
I think there's three things.
The conundrum that we run into is you have a motion on the floor that fails for that very reason.
Right.
Okay? Do you then have another vote to find no violation? I think it has to be clear to the public as to what what the determination actually means. It's very clear if there's a violation, what that means. It's very clear that if the motion fails to find a violation, what that means. Okay, that, yeah, some people, the majority did not find that there was a violation, so to me, that would sound like there's no violation, because it fails. The majority, well, you're right, the problem is because of this 6-vote kind of thing. But essentially the majority did not find. So, well, it's kind of tyranny of the minority at that point, to tell you the truth.
I think Member Yankee and I discussed, we came up language with this at a previous iteration.
I was going to say the only issue I have is technically, let's say we're going to vote on, I'm just going to make something up, a violation of 6721. And let's say it goes, what do we have, 7 people here? Let's say it goes, or at least let's even say you get a majority that say that we don't find a violation of that. That still doesn't mean that the body found no violation of anything. All that means is we didn't find a violation of 6721. I mean, there might be other provisions. So voting against a motion to find a violation is different than, I think, voting for a motion to find no violation. That makes sense.
Yeah, I guess
it's a semantics a little bit.
But my question is there
right.
a need to have a motion for no violation? I mean, it makes it clear
right.
if there's a motion, if somebody calls for a motion to find no violation and that fails, does that mean that there is a violation? And what if nobody makes a motion then to find a violation? Then you're stuck in a quagmire.
I mean, I don't know. Could there be some type of bylaw that if no motion is made, that the chair by default makes the motion?
Well, but see, that's why I was suggesting it be a little more like in a courtroom. In a courtroom, the question is clear. The question is always there. Nobody has to make a motion for it.
Right. That's,
okay.
Yeah. Who would call for it? The clerk?
No, it just exists by virtue of the complaint. Somebody filed a complaint that there's a violation. Well, we
have
just
that too.
like we consider all documents to be public, we will start with that there's a violation until the respondent proves otherwise.
We start with that too. We start with the complaint.
We start with the complaint.
So it'd almost be like an automatic motion. I mean, that.
Like nobody needs to make a motion.
Like after the close of rebuttals and conversation and everything, then it's just call the vote.
That doesn't work though, because sometimes we're considering multiple violations, and some you may agree with, and some you may not.
That's why, yeah. And we talked about in rules is maybe before we call the vote on the initial allegation. Let's say someone writes and they think there's an allegation of 6721. Maybe perhaps the first question is, are there any amendments to the initial complaint?
Right.
Or the maker of the
if there
motion
aren't
can
any,
add them.
no one makes a motion to that, then we vote on that. If someone wants to amend, change it, add to it, whatever else, then that becomes the new thing we vote on.
Right.
But I think you're right. I think we need to vote on something by default at the end.
Right. So I see you, DC Thoreen. I just want to say this, that lots of times we get folks filing complaints that don't know the ordinance. They just know that they didn't get the documents, so we have to fill in that blank. Okay, so there's that little twist in there also. So, yeah, DC Authority.
Exactly the point I was going to make is that two points. One is that, on one hand, they should stand or fall on the allegations that they make as to what they did or didn't get under what statutes. But on the other hand, when we draft these memos all the time, we have people who don't understand all of the statutes that might be in play. And so, but I think the basic question is, was there a violation? Yes or no?
Right. So I guess my original thought in this was that it be more like in a courtroom. Nobody has to move or second the motion. Okay, because that's why the last line is in there, because in parliamentary procedure, the maker and the second can vote against the motion that they make. They just can't speak against it. They can vote in the opposite direction. They just can't speak against the motion that they make. They can rescind it, and then it goes away, and then somebody else will make a motion. That's generally how Robert's Rules works. Member Kate.
Yeah, sorry to just kind of go back and, what are we amending, or what?
We're creating something new. It's kind of a part of the, it's part of the complaint procedure with regards to the order of determination.
Could I read something from the October 2018 Rules Committee minutes that Member Yankee and I were there with? Language we came up with was as follows. In the absence of a motion, the SOTF is encouraged to make a motion to find no violation. Second, vote on that to provide a clear closure on that item.
Right. So, but here's a question. Somebody says, okay, I move to find violation 6721A. That votes down. Somebody else makes a motion. Well, I find to find a violation of 6721B. Okay. I mean, you go down that road. That's fine. There's nothing wrong with that. You can continue to go that way. We've done that before. But I guess clearly it's more about if no one makes a motion. That's what I'm more concerned about. We have been in that place before.
What about the original suggestion of changing violation to determination? Didn't that essentially unwind that? Like, why do we move past that?
Well, because I'm still concerned also about if no motion is made. How does that get considered?
Right, I'm trying to think, is there a way to force it so no one has to actually make that motion? Because there's sometimes that awkward place where, we all think there's no violation. We had that, obviously, we talked about that in the beginning when we reconsidered that one, where someone might want to talk into them. I think it's kind of, so I'm just trying to think of a way that, a trigger where we, just like you said, by default, so no one actually has to make that motion, no one has to second it.
Yeah, go ahead.
Actually, this has come up in the clerk's office regarding our agendas and some of the bodies. They wanted us to consider copying the board's practice of putting the motion on the agenda. The board generally puts, shall this ordinance be adopted on all items? We put something on our agenda, shall a violation be found of the Sunshine Ordinance, and just not list a number? And we can add that number in at a later point, or something to that effect.
Well, yeah, and that way nobody has to necessarily make a motion.
Right. Then we're basically, to move on the agenda, we have to take a vote.
Right.
If we're on file number 8, we can't go to 9 until we vote.
Right.
On it somehow.
I mean, I'm not going to get into discussion about abstentions. That's a different, longer conversation with regards to whether that's allowable or not. But I think just having the question before us, if as the case starts, that's the question.
Right.
And then we go through the process to try and answer the question, and in the end, we answer it by just voting on it.
I will
There's no
call the
need.
question.
And
I'm
so
sorry?
we can.
The clerk calls the question.
Yeah, the clerk calls the question, and by the same token, you can look at any one of the memorandums that we receive from our legal counsel, and they state an area that says applicable statutory sections, and so basically that is kind of the list of possible violation areas.
And so if we don't add a section, and because nobody thinks there's a violation, but we're still saying, shall, what was the wording you used?
Just of the Sunshine Ordinance.
Of the Sunshine Ordinance. And if we all say no, it doesn't matter that there aren't any sections on it.
I don't think that's
We could
appropriate.
put the section in based upon their requests. A lot of times I put in that number for the applicants based on what we read.
He helps them kind of like formulate.
Yeah, I think I think we should probably start with what the initial complaint was.
And then we can always
change
amend that
it
question as needed during the
as
meeting.
we go through, but I think that should be the default
The
question,
maker,
because that's what
the maker of the
started
motion
it.
can go straight to another section of the code, and that could be what we vote on, not what was originally put to us.
Right, we can, I mean, if it starts with, like I said, if the default question was, shall there be a violation found for 6721, because that's what they put in their complaint, at some point we can certainly change it as we go. But absent anyone changing, I think that's a bare minimum we owe the person who made the complaint an answer to what their initial complaint was.
Sure.
Right. I think, maybe it would behoove the committee that's hearing the complaint because our legal counsel would have already done a memo for the case to be able to identify and make a recommendation when it comes up here in conjunction with the.
Maybe the committee can state which code they believe is applicable.
Yeah, it could be that. I mean, for instance, there are other cases where we need possibly to just take it on kind of prima facie because people specify what they think is the violating code. And the question is if they're going to state a specific code, is that the question before us? And if so, and then it's becomes, we've had some cases where, people say, well, I think it's a violation of 6721D, and then somebody says, okay, is there a violation, there's a motion for 6721D. It fails. That's the end of that, because the petitioner is the one that specified the code violation. And so nobody feels compelled to make another motion, even if there's a violation of some other code.
No, hopefully someone would be compelled to make.
Hopefully, but that's not necessary, not required.
Did we, I'm sorry, this sounds very familiar. Did we do something about this already?
We did.
Recently? I'm trying to figure out.
Let me read this. This is from a year ago. It was you, myself, and Member Yankee.
Right.
But Rules Committee.
Rules Committee.
Also
Member Kate, second by Member Highland, moved to refer the matter to SDIV with a recommendation to amend bylaws Article 4, Section 10 as follows. A, make a motion to find a violation. B, make a motion to find no violation. C, make a motion to take no further action and close the file.
But what did the task force do?
And D, do none of the above.
Yeah, but that was from the committee. What did the task force do?
Let's take a look. So that would have gone to.
What year was that?
That October 2018. So this probably would be November, full task force. Let's see.
Okay.
All right.
Thank you, Peter.
I can do that one. Or it's not the Wednesday, it's the Tuesday, right? It's the day before, so I don't know why it says.
October 5th?
That was October
No.
23rd, Rules Committee 2018.
Oh, right.
So let's say it went to.
It depends.
Yeah, we spent a lot of time on
It
this.
was December, and the motion was the task force may vote to take one of the following actions, including but not limited to: A, make a motion to find a violation; B, make a motion to find no violation; C, make a motion to take no further action and close the file. Period. And that passed by all 9 votes at that full task force meeting.
I'm really sorry. I need to leave. Okay.
Enjoy your trip. What item number was that?
8, file number 18082, and the December 5th, 2018.
Oh, okay.
There it is, yeah.
Okay, I apologize. I guess because I don't know if the bylaws were updated.
Yeah, I don't think so, because I looked at them.
Cheryl still has the old ones up. Yeah, I've mentioned
Right,
that
the
to her
old
Okay,
ones are
also.
so maybe that's why.
Yeah, she needs to put the new, because we've amended them, I
Okay.
think, a few times.
So we actually dropped D, do none of the above, and that passed 9-0. That's what happened in the end. Do none of the
Well,
above
wait a
was
second.
stricken.
So,
Page 5.
wait a second. It says Administrator Young stated that this change can be noted, but because this is a bylaws change, it needs to be continued to a future date, as this change needs to be noticed at the public library before the language can be adopted.
Does that happen?
So we voted to do this, but then because of the process,
Yeah, let's see
and
if
I
that's-
don't know that I think maybe that was the transition when Cheryl came in. So,
Victor, did you hear that?
Yes, it is. And if you give me the details, I will look into it and we'll get that scheduled.
No, it looks like it came
18
back up in January, and then we passed it then.
Say what?
Looks like it came back up in the January meeting, and we passed it then.
Hold on.
Item number 10.
January meeting.
January
Item
number
number
10.
Be great if we could.
Bylaws, there's further members saying to adopt a proposed amendment. Okay. All right, then it is what
I
it
will
is.
double check and I will
It's the law of the land.
make sure that the most recent version of the bylaws get uploaded to our website.
Okay. Thank you very much.
But
All right.
Does that still settle that issue, though? I mean, should we still have further discussion about
I think it's settled for the evening.
for the evening?
Well, if you feel, and not now, but if you feel in the future,
Yeah, I mean, personally, I think the idea of having, maybe we talk about it more later, but the idea of having the question called by the clerk at the end and, put as part of the agenda, I think.
right. Oh, I needed to, for the next item, we actually needed Member LaHood.
Right, I think we probably, and I know,
Do you know what the answer is? But let's get to it first. Can we move, any public comment on this item? Seeing no public comment, okay.
I was wondering, do you want me to add questions to the agendas or not? Or just go with the policy from the
I
January?
don't know, what do you think?
Maybe, could you maybe do like a
I have to do it.
You don't have to
report on how
follow
it
the
works,
question.
What?
or, I mean, at the next meeting, maybe give a short, when
Guys.
more of the task force is here to.
Okay.
If
Describe
I
how that
leave,
works.
do we not have quorum?
We now have quorum.
I have to meet someone in 10 minutes.
Well, the next item was really important because there are people waiting.
I have.
Can you give us 3 minutes?
No, I'm 10 minutes late already.
They're going to do it without us then. They're going to
What
change, they're going to put forward a motion, to amend the sunshine ordinance to change to the minority seat. And there are issues that League of Women Voters and SBJ had, and we don't know what they were. That's where we left it. And we were supposed to take this up at the last meeting, but it didn't get agendized.
Can it come up in the next subcommittee?
It can't be approved, has to be approved by the task force.
What? And there's going to be action taken on it before our next meeting?
We want, yeah, the certain supervisors want to hear from us on this.
Well,
Hear it and vote?
Well, but we don't have it from the League of Women Voters, their representative isn't here.
Right.
And do you know what the SPJ position is? Well, let's call the item first.
okay.
Item number 13, review of parliament, item 14, report regarding Prop B intending on privacy and proposed changes to the SOTF seats, descriptions, and appointing authority.
I mean, I don't know, I know we've talked about this before. I know the SPJ's position as of the last time we spoke. For everyone's edification, they're going to try to, the Board of Supervisors, led by the SPJ's effort, I suppose, wants to amend the ordinance to basically fill the vacant seat, change the requirements for the seat that is vacant, and fill it with, my understanding is a member minority group who's an SPJ member. I believe that's right. There's concern about whether or not that, because of the Prop B and fiddling with the Sunshine Ordinance, that's a problem that raises a concern. I don't know that we can really talk about it a lot because member Tesfaye is not here. The SPJ ultimately believes that it can be done and be consistent with the purpose of the Sunshine Ordinance because Prop B only allows, according to the text of Prop B and the ordinance that's passed, changes to the Sunshine Ordinance that are consistent with the purpose and intent of the Sunshine Ordinance. And the SPJ's position, and it's one that I share, is that the ordinance exists as it is, Prop B exists as it is, rather, and we can use this for good, is the short way of putting it, and we've got an empty seat, and we don't necessarily like that Prop B is there, but we can use it to, consistent with the purposes of the Sunshine Ordinance, fill a position that's been vacant for more than 2 years, I think now. Because otherwise, it's just going to sit there barring another proposition by the voters. And that's basically the position of the SPJ on the issue, as I understand it, as we've discussed. And I know it's a ball of wax that not everybody's going to agree with.
Do you want to make a motion?
No, I don't think. I mean, I just don't. I don't think enough people are here who are implicated and who have serious concerns about this. I don't think this is the right time, and I know the timing is tight, and I'm not trying to.
I will suggest this then. I will call a special meeting when both get back, okay? And hopefully we'll have quorum. Whoever shows up, shows up. But at least we hear from those two folks, because that's why we're waiting, right?
Okay.
Not to make a decision. I mean, I have my own concerns about this, because I think that particular part of Prop B was meant for the purposes for Prop B and not for any other purpose.
Yeah,
Is it all right if I bail now?
Yeah.
do we have to make a motion to adjourn?
As soon as he leaves, we're
Yes,
adjourned.
we automatically adjourn. So just let's close this. I'll call for a special meeting. I want Member Kate to make an announcement, his announcement.
Right. My announcement is that I have not yet told my current employer, but I've taken a new job. I'm in Washington. I don't like leaving the Bay Area, but I am going to be leaving in November. Details I'm still ironing out, so I'm going to have to step off because that's a hell of a commute. And
Washington State or
Washington D.C.
Oh,
and so it's even further out. And so, I mean, I'm really excited about the opportunity. I've really enjoyed working on this task force and with all of you and all the members who are not here. I think we and you all do important work, and I, support you. I hope to be here for November's meeting. I can be here and will be here for the complaint committee meeting at the end of the month, if we're still having it. And but if on the chance I'm not here, I really appreciated and enjoyed working with all of you, and I just hope that you keep it up. And I really appreciated this opportunity.
Thank you for your service.
Yep.
yeah.
When will this be effective?
I don't know yet. And do you know now that we're in adjournment?
That's okay. We just can't make, really, we just can't
I'm gonna
make
stop
any
the recording.
actions.
Thank you.
Just can't take any actions.